already there as part of the compilation. Then I hope your lordships have the hard copy which was handed over on Friday.
Yes, there is one, your written submission is of 15th March.
That's right, 15th March. I just took copies of that and then handed over for the sake of convenience. They are not, there's only one set of written submissions, which I had filed it.
Soft copy. Is it the same soft copy?
Same.
Oh,
It's the same. But in the soft copy, in the compiled, it's volume 5.1.
Volume 5.1.
I'm sorry, 1.1. 1.1.
1.1.
Yes. It starts at page 4. All written submissions come in that volume. But I handed over only for the sake of convenience.
Yours will start with?
Page 4.
That's it.
That's the first set of written submissions.
But were you not on last time on page 16 or 17?
I was reading from that.
Oh.
At one point of time, Lord, probably.
Anyway, you can start from wherever you want.
My Lord, I had made a submission, but then I thought, my Lord, short recapitulation, and then I'll not repeat what I have stated, except that to put it in perspective, if your lordships kindly come to page of this, my Lord, I have dealt with the issue-wise. Issue 1 and 2. Issue 1 is a scope and ambit of right to freedom of religion. Sorry. Page 6, my Lord. I'm sorry. In the PDF, it is page 10, my Lord. I have two page numbers. One is this pagination. The other one is the one in red ink. I'll probably refer to that, my Lord. Maybe that will be better. The red ink, my Lord, it is page 10. That's because it's a running page, my Lord, in the compilation, in the soft copy, which is, I just reproduced it. And therefore, I'll go by this page number, left and top in red ink, my Lord. Page 10. First issue is scope and ambit of right to freedom of religion under Article 25 of the Constitution of India. And issue number 2, interplay between the rights of persons under Article 25 of the Constitution of India and rights of religious denomination under Article 26 of the Constitution of India. My Lord, I'll just read this, and then, my Lord, I'll make my submission shortly. Under Article 25(1) of the Constitution of India.
Where are reading page?
My Lord, page 10, my Lord, if your lordships have the
paragraph, running paragraph
red color. Para number, my Lord, 22.
You can refer the running paragraph, that will make easy. Para 22.
Para 22.
Questions are above para 22.
Your lordships are right. Para 22.
Yes.
Para. Under Article 25(1) of the Constitution of India, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. This is expressly made subject to public order, morality, and health, and the other provisions of Part 3 of the Constitution. For instance, the right under Article 25(1) would not allow a man to commit human sacrifice because the said act is a crime and it would be in contravention of public order and morality. Ban of animal sacrifices in temples by law would not be violative of Article 25(1), as such ban would only be in support of public order, morality, and health. Right under Article 25(1) is also subject to the other provisions of Part 3. Thus, the individual's right to freely propagate and profess one's religion would be construed as subject to the right available to a religious denomination or a section thereof, inter alia, to manage its own affairs in matters of religion. Under Article 25(2) of the Constitution, any economic, financial, political, or other secular activity which may be associated with a religious practice could be regulated by a law made in that behalf. This Honorable Court has upheld provisions contained in law that dealt with the regulation or restriction of any economic, financial, political, or other secular activity which may be associated with religious practice. My Lord, I give the list of judgments: Shirur Mutt, Ratilal, Tilkayat, Dargah Committee, and Sheshammal, Narayana Dikshitilu, and then, my Lord, Adi Vishweshwara of Kashinath Vishwanath Temple. While upholding the validity of laws sought to be justified under 25(2)(a), this Honorable Court has at the same time struck down provisions of the same law that interfered with the actual religious practice in Sardar Syedni Saifuddin. In the judgment mentioned above, the issue was regarding the constitutional validity of the Bombay Prevention of Excommunication Act. The Act inter alia prohibited the head of the Dawoodi Bohra community, called the Dei, from excommunicating a member of the community on grounds including religious ones. Salient provisions in the Act were declared to be unconstitutional as it was held to be violative of Article 26, dealing with the rights of the denomination. And, my lord, there were two judgments. One is Justice Dasgupta and the other is Justice Rajagopala Iyengar. I've given the paragraph numbers of each one of them. This was one of the instances where this Honorable Court upheld the right of the denomination under 26B to prevail over the rights under 25(1). And in the context of the same, the statute which purported to ban the power of the religious head to excommunicate a member and take shelter under 25(2)(a) was found to be ultra vires Article 26. It is submitted that the approach made by this Honorable Court in this regard in the aforementioned judgment has also been referred to by the learned constitutional author H.M. Sirvai in his commentary on the Constitution of India. My lord, I have given the volume, I have given the paragraph numbers. Why, my lord? Because it is not part of the compilation, my lord. And then, my lord, I get into my own submission. An essential feature of Hindu religion is the worship of idols. After a deity is installed, it should be worshipped daily according to Hindu Shastras. The deity, in short, is considered as a living being. A deity is a juristic person. And then, my lords, every Hindu deity has characteristics of its own. The rituals and ceremonies followed in a temple would be either unique or at least peculiar to the temples which come under the same category. The rituals are also always associated with the concept of the deity. For example, the rituals and ceremonies that are followed in a Shaivite temple would be different from the rituals and ceremonies that are followed in the Vaishnavite temple. In this light, it was held by this Honorable Court in Sheshammal, my lord, the citation of Sheshammal is also given separately, my lord. Yes. Now, my lord, para 11 and 12 of Sheshammal are extracted. I beg to, my lord, read this, my lord, because it puts my submission in perspective, my lord. See, before we turn to these questions, my lord, this is part of extracted, therefore, in paragraph 25, it will be necessary to refer to certain concepts of Hindu religious faith and practices to understand and appreciate the position in law. The temples with which we are concerned are public religious institutions established in olden times. Some of them are Shaivite temples and the others are Vaishnavite temples, which means that in these temples, God Shiva and Vishnu in their several manifestations are worshipped. The image of Shiva is worshipped by his worshippers who are called Shaivites, and the image of Vishnu is worshipped by his worshippers who are known as Vaishnavites. The institution of temple worship has an ancient history, and according to Dr. Kane, temples of deities had existed even in the 4th or 5th centuries. See History of Dharmashastra, Volume 2. With the construction of temples, the institution of archakas also came into existence. The archakas being professional men who made their livelihood by attending on the images. Just when the cult of worship of Shiva and Vishnu started and developed into two distinct cults is very difficult to say, but there can be no doubt that in the times of Mahabharata, these cults were separately developed and there was keen rivalry between them to such an extent that the Mahabharata and some of the Puranas endeavored to inculcate a spirit of synthesis by impressing that there was no difference between the two deities. With the establishment of temples and the institution of archakas, treatises on rituals were compiled and they are known as agamas. The authority of these agamas is recognized in several decided cases and by this court in Venkatramana Devaru. Agamas are described in the last case as treatises of ceremonial law dealing with such matters as the construction of temples, installation of idols therein, and the conduct to the worship of the deity. There are 28 agamas relating to the Shaiva temples, the most important of them being the Kamik Agama, the Karana Agama, and the Suprade Agama. The Vaishnavas also had their own agamas. Their principal agamas were the Vikhansa and the Pancharitra. The agamas contain elaborate rules as to how the temple is to be constructed, where the principal deity is to be consecrated, and where the other devas are to be installed, and where the several classes of worshippers are to stand and worship. Where the temple was constructed as per the directions of the agama, the idol had to be consecrated in accordance with an elaborate and complicated ritual accompanied by chanting of mantras and devotional songs appropriate to the deity. On the consecration of the image in the temple, the Hindu worshippers believe that the divine spirit has descended into the image, and from then on, the image of the deity is fit to be worshipped. Rules with regard to daily and periodical worship have been laid down for securing the continuance of the divine spirit. The rituals have a twofold object. One is to attract the lay worshipper to participate in the worship carried on by the priest or archaka. It is believed that when a congregation of worshippers participate in the worship, a particular attitude of aspiration and devotion is developed and confers great spiritual benefit. The second object is to preserve the image from pollution, defilement, or desecration. It is part of the religious belief of a Hindu worshipper that when the image is polluted or defiled, the divine spirit in the image diminishes or even vanishes. That is a situation which every devotee or worshipper looks upon with horror. Pollution or defilement may take place in a variety of ways. According to the Agamas, an image becomes defiled if there is a departure or violation of any of the rules relating to worship. In fact, purificatory ceremonies have to be performed for restoring the sanctity of the shrine. Worshippers lay great store by the rituals, and whatever other people not of the faith may think about these rituals and ceremonies, they are part of the Hindu religious faith and cannot be dismissed as either irrational or superstitious. An illustration of the importance attached to minor details of ritual is found in the case of so and so, His Holiness Periyakovil, so and so, my Lord, that is in 73 Indian appeals, which went up to the Privy Council. The contest was between two denominations of Vaishnava worshippers of South India, the Vadagalais and Tengalais. The temple was a Vaishnava temple, and the controversy between them involved the question as to how the invocation was to begin at the time of worship and which should be the concluding benedictory verses. This gives a measure of the importance attached by the worshippers to certain modes of worship. The idea most prominent in the mind of the worshipper is that a departure from the traditional rules would result in the pollution or defilement of the image, which must be avoided at all costs. That is also the rationale for preserving the sanctity of the Garbhagriha or the sanctum sanctorum. In all these temples in which the images are consecrated, the Agamas insist that only the qualified archaka or pujari shall step inside the sanctum sanctorum, and that too after observing the daily disciplines which are imposed upon him by the Agamas. As an archaka, he has to touch the image in the course of the worship, and it is his sole right and duty to touch it. The touch of anybody else would defile it. Thus, under the ceremonial law pertaining to temples, even the question as to who is to enter the Garbhagriha or the sanctum sanctorum and who is not entitled to it, enter it, and who can worship and from which place in the temple are all matters of religion, as shown in the above decision of this court. The Agamas have also rules with regard to the Archakas. In Shaivite temples, only a devotee of Shiva, and thereto one belonging to a particular denomination or group or subgroup is entitled to be Archaka. If he is a Shaivite, he cannot possibly be an Archaka in a Vaishnavite Agama temple, to whatever caste he may belong and however learned he may be. Similarly, a Vaishnavite Archaka has no place as an Archaka in a Shaivite temple. Indeed, there is no bar to a Shaivite worshipping in a Vaishnavite temple as a lay worshipper or vice versa. What the Agamas prohibit is his appointment as an Archaka in a temple of a different denomination. Dr. Kane has quoted the Brahma Purana. Sorry.
P.V. Kane.
Kane, I'm sorry, Dr. Kane, I'm sorry. I stand corrected. Has quoted the Brahma Purana on the topic of.
It is written on Dharma Shastra. Classical.
Sorry, my Lord. Mr. Gopal Subramanian had corrected me earlier, but I'm a slow learner, my Lord, maybe because of that.
Dr. P.V. Kane.
Panduranga Vaman Kane.
Okay. Dr. Kane has quoted the Brahma Purana on the topic of Punapradishta, reconsecration of images in temples, at page 904 of his History of Dharma Shastra, referred to above. The Brahma Purana says that when an image is broken into two or reduced to particles, is burnt, is removed from its pedestal, is insulted, has ceased to be worshipped, is touched by beasts like donkeys or falls on impure ground, or is worshipped with mantras of other deities, or is rendered impure by so-and-so, and in these 10 contingencies, God ceases to dwell therein. The Agamas appear to be more severe in this respect. Our Parthasarathi Bhattacharya, whose authority on Agama literature is unquestioned, has filed his affidavit in petition and stated in his affidavit with special reference to the Vaikansa Sutra, to which he belongs, that according to the text of Vaikansa Shastra, persons who are the followers of the four Rishi traditions of Bhrigu, Atri, Marichi, and Kashyapa and born of Vaikansa parents are alone competent to do puja in Vaikansa temples of Vaishnavites. They only can touch the idols and perform the ceremonies and rituals. None others, however, placed in society as pontiffs or acharyas or even other brahmins, could touch the idol, do puja, or even enter the Garbhagriha. Not even a person belonging to another agama is competent to do puja in Vaikansa temples. That is the general rule with regard to all these sectarian denominational temples. It is therefore manifest that the archaka of such a temple, besides being proficient in the rituals appropriate to the worship of the particular deity, must also belong, according to the agamas, to a particular denomination. An archaka of a different denomination is supposed to defile the image by his touch, and since it is the essence of the religious faith of all worshippers that there should be no pollution or defilement of the image under any circumstances, the archaka undoubtedly occupies an important place in the matter of temple worship. Any state action which permits a defilement or pollution of the image by a touch of an archaka, not authorized by the agamas, Lord, this sentence would violently interfere with the religious faith and practices of the Hindu worshipper in a vital respect, and then, my lord, the court says, would therefore be prima facie invalid under 25(1) of the Constitution. This is how, my lord, in Sheshammal, a consideration the principles, my lord, with regard to the consecration of a deity and thereafter the manner in which these pujas are performed. And when there is a deviation from that, how it would become invalid under 25(1) is what is mentioned, my lord, in Sheshammal. That's how the link is established between the mode of worship, a deviation therefrom, and how 25(1) would probably be attracted there. This is what is stated in, my lord, Sheshammal. Hindu religion therefore considers the deity as living being. Consecration of the deity undergoes an elaborate procedure under the Agama Shastras. Generally speaking, all these ritualistic treatises insist on a preliminary ceremony by which the idol is purified and cleansed from all impurities that attach to it at the hands of the artist. For understanding the concepts, the Shastras could be referred to. The infusion of life to an idol so as to make it a deity is therefore an elaborate procedure. And then, my lord, my lord, I'll just read this next paragraph coming under the heading of A. Right under, and this is, my lord, this is part of my submission. Right under Article 25(1) will have to be exercised in consonance with and not in antagonism to the essential characteristics and external practices of the religion. Article 25(1) of the Constitution provides for the right to practice and propagate one's religion. A Hindu and a believer in idol worship would therefore seek to go to a temple in affirmation of his right to practice his religion as a fundamental right for the purpose of worshipping the deity. For him, her, it is an act of devotion. It is an act of worship. When the devotee therefore goes to the temple for worship, it cannot be in antagonism to the characteristics of the deity because it is for the purpose of worshipping the deity. The devotee subjugates himself, Lord, what we call a surrender, himself to the divine spirit contained in the deity. She will therefore have to accept the essential characteristics of the deity. For example, he cannot go to the Shiva temple and then say that, I am a believer of God, I believe in idol worship, I believe in Lord Shiva, I also believe in Lord Vishnu, but I would like to see the ceremonies performed in a certain Vaishnavite temple to be performed here. The nature of the ceremonies and rituals followed in any temple forms an integral part of the religion practiced in any temple. It is a religious practice. Therefore, continuance of such practice in the temple, which is an essential religious practice, would be part of the right to worship that inheres in every member who believes in such a religion or is a member of the denomination. If Naistic Brahmacharya, therefore, can be considered as an essential characteristic of the deity, and the ceremonies and rituals that are performed in Shabarimala is in synchronization with the said concept, then no member of the denomination or a section thereof, and no person who believes in the idol in the temple and would consider the deity therein as his Lord can act in derogation of the essential characteristics of the temple, because in such a practice cannot be treated as part of the practice of his religion. No, my lord, I'll stop here for a moment. And therefore, my lord, the submission is this, my lord. It has been captured in this. But to put it in my own words, my lord, for the purpose of linking it to Article 25(1), I have a right, my lord, to practice my religion under 25(1). I believe in that. And therefore, my lord, when I go to a place of worship, public place of worship, no, my lord, I believe in the deity. This is what I said, my lord, on Friday also. I'm just repeating it just to put my arguments in perspective. My lord, I should believe, my lord, in the place. I should believe in the deity. My lord, it has, therefore, I don't, my lord, I can't lack in belief there and still go to a place of worship for the purpose of worship. My right to worship under 25(1) is therefore intrinsically connected to that. There is no question of going to a temple to find out, my lord, to what are the characteristics. No, I know that. It is part of my right. I believe in the deity. Wherever I go, whichever is a public place of worship, whichever is, either it's a church or a mosque, I should believe in the concept. If I don't go there, my entry is not protected under 25(1). My right under 25(1), insofar as it encapsulates or captures, my lord, a right to enter the place of public worship, will have to be in sync with the concepts, my lord, or with whatever the practices are that are carried on in the temple as such. And characteristics of the deity is treated as one of the integral parts, my lord, because idol worship, and therefore, my lord, worship of the deity is considered to be an integral part of the Hindu religion. Therefore, when I go to the temple, I go there for worshipping the deity. If I don't believe in the deity, why should I go there? And therefore, if the characteristics of the deity are such that it is not possible for me to go there, if I am a woman, my lord, it comes into the merits of Sabrimala. Therefore, I'm not touching on this now at this stage. But point is, my lord, this. It has to be in sync with the characteristics of the deity. And characteristics of the deity, insofar as Sabrimala is concerned, contemplates that the deity is a permanent celibate.
Need to take it to that extent of essential or integral. We understand your argument.
I understand, my lord. I don't have to get into, my lord.
As you rightly said, if there is a link, if the practice 25(2)(b), they have right to take action. It is not, for the moment, we will not talk about the court's role. We will talk about the enabling power being exercised
That's
by way of a law. So
That's-
then what is it court should do?
That's right.
So when one is with respect to with the existence of as a social reform or social welfare, vis-a-vis the religious practice is there. So we can take your argument to the extent it does involve a religious practice, but so long as it is connected to the religious belief.
Correct.
Please be very careful. Don't enter into the arena. Is what you are saying.
That's right.
To
That's
that extent, we can expand.
Yes.
Let's say we need not even go to the integral or essential.
Yes.
But when it connected to the religious practice, be very careful in
Be
this.
careful. Yes. That's it.
In other words,
Yes.
a believer will not question the rationality of that.
Should not be.
practice.
That's correct. A believer will not.
Not question. And it is no business for a non-believer to question it.
That's right.
Because he is a non-believer in any way.
And therefore, it is anyway not captured under 25(1). Your Lordship will have to put it on the constitutional platform. Your Lordships will say, I don't believe in this religion, then why should I? Or if I come to that, why should your Lordships protect my right under 25(1) as to go and question the belief which is inherent in another place of worship? I can't do that. It is not captured by 25(1). My Lord, para 28, my Lord. It is straight law, as has been held in Shirurmat and other judgments by the Supreme Court itself, that what constitutes an essential part of the religion is primarily to be ascertained with reference to the doctrine of that religion itself. Therefore, the content of the right claimed would have to be ascertained with reference to the tenets of the religion itself. This would include the concepts relating to the consecration of the idol and the individual characteristics of the deity. There is a total lack, sorry.
Yes, please.
There is a total lack of any material on the part of the writ petitioners, my lord. I have there's one sentence which came in on the merits to show that the concept of Naishik Brahmacharya as pleaded by the review petitioners is either ill-founded or misconceived, or that it does not form an essential part of the religion. I'll skip para 29, my lord. Para 30 to 39, I would beg to read it before your lordships, because, my lord, this is where a lot of arguments have been addressed, my lord, by my learned senior friends. And my lord, see, and it is one of the issues which have been raised for consideration.
Yes.
But I'll just read it, my lord, from para 30 to 39. What constitutes a religious practice has to be determined with reference to the doctrines, practices, tenets, historical background, etc. This Honorable Court in Shirur Mat observed, in para 20 of Shirur Mat, what constitutes the essential part of a religion is primarily to be ascertained with reference to the doctrines of the religion itself. If the tenets of any religious sect of the Hindus prescribe that offerings of food should be given to the idol at particular hours of the day, that periodical ceremonies should be performed in a certain way at certain periods of the year, or that there should be daily recital of sacred texts or oblations to the sacred fire, all these would be regarded as parts of the religion, and the mere fact that they involve expenditure of money or employment of priests and servants or the use of marketable commodities would not make them secular activities partaking of a commercial or economic character. All of them are religious practices and should be regarded as matters of religion within the meaning of Article 26B. Para 31. This Honorable Court in Tilkayat Govindlalji Maharaj stated that the test to determine an essential religious practice must be whether it is regarded as such by the community following the religion or not. This has been followed by this Honorable Court in Adi Vishweswara. Therefore, the content of the right claimed would have to be ascertained with reference to the tenets of the religion itself. This would include the concepts relating to the consecration of the idol and the individual characteristics of the deity. It is submitted that in the present scenario, the community, particularly in Kerala, has accepted the custom as an integral part of the religion and practice. It is further submitted that women folk in Kerala realize the significance and have been cooperating with the system wholeheartedly. The women in their homes utilize the spirit for spiritual discipline. Thus, the occasion becomes a period of harmonious cooperation between men and women. And, my lord, I refer to Dargah Committee and the manner in which Dargah Committee has, my lord, struck a slightly different note from Shirur Mat. I'll just read these to Dargah Committee and Tilkayat, and the manner in which, my lord, it has been criticized, my lord, in the, or referred to by Ms. Sirvai in his treatise. In Dargah Committee, this Honorable Court proceeded to strike a note of caution and observed that even practices, though religious, may have sprung from merely superstitious beliefs, and in that sense may be extraneous and unessential accretions to the religion itself. The court therefore held that the protection must be confined to such religious practices that are an integral part of it and no other, and was pleased to further find that the protection under Article 26 may have to be carefully scrutinized. It is submitted that in a subsequent
Are you propounding this essential religious practice? See, either it is secular activity
That's all.
associated with a religious practice,
Yes,
or it is a religious practice.
that's it. That's it.
Once it is a religious practice,
Then
why
there was
not
no question of,
essential, non-essential?
that's correct, it doesn't come. That's what I have stated, my lord, in the following paragraphs, my lord, there.
Are you expecting again that there should be a determination?
No. Doesn't, my lord, the question as to whether it should be that, where the statement that it should be ascertained with reference to the tenets of the religion is only to show that it is a religious practice. One doesn't, my lord, if it is with reference to the tenets of the religion, it's a religious practice, whatever it is.
So you
There
may be
cannot
correct-
be, sorry.
may be correct, Mr. Giri.
Yes.
But then again, we come back to the moot question. There has to be some sort of even a threshold, prima facie or tentative aspect has to be gone into whether it is a religious practice. So we come back to the same question, to what extent? But there has to be some consideration that yes, this will fall into a religious practice. So there has to be. you
In
have to assess
contrast
that.
with whether it's a secular practice or not.
Once you determine a practice is stricto sensu secular practice, all others become religious practice.
Yes.
So where is the question of any authority or questioning whether it is a essential
That could be.
religious practice
That could be.
or a religious practice?
Yes. The line of inquiry could be
Secular
this.
practice or not has
Yes.
to be determined.
Yes.
That
Yes.
the court can determine.
That the court can, and no further.
Then anything else would be a religious
No.
practice.
My lord, I also say, when does the court interfere? If it is against the public order, morality, or health, my lord, the court is entitled to interfere, even though, my lord, under 25(1), those words are actually used, my lord, in 25(2), even though. But that far and no further. Therefore, two platforms of inquiry. One, whether it is secular or religious. Find that it is not secular, religious, stop there.
Then it has to be taken on a case-to-case basis, issue-to-issue basis.
No, my lord,
Then why, if there's a so
Generally-
simplistic, then it has to be on a
no,
issue-to-issue
the
basis.
practice, my lord, a practice of a religious practice is associated with the religion, my lord, as a whole, need not be taken as a case on a case-to-case basis, my lord. There could be a practice, my lord, which says that is associated to the religion, my lord, as a whole.
Now the exact circumstances or the situation, that we are not. But then it has to be, unless somebody challenges that this is a secular, no, this is religious, then again, then what
Lord,
are we actually going to do?
No, the challenge is always, my lord, the challenge has always been on the ground. When there is a state interference, there is a challenge, my lord, on the ground that this is not a secular aspect, and therefore, my lord, the state cannot interfere in that.
Sir,
Challenge has always been that way.
can we then say to the extent that if I am believer, I need not be rationally. I am believer, enough. Is it that?
Sorry, my lord, I didn't follow you, lord.
Is it taking us to that submission that if I am believer, I may not be used rationally. I am a believer, that's enough. I need not see whether sometime, even if a believer feel that whether this is rationally or not.
No, my lord, that is
At what extent then believer will be only thinking if this is a long-standing practice accepted, I should follow it. Without giving, going into all the other aspects, it is possible that a believer at some time in earlier years was thinking in that way. A believer now, with the advent of technology, with the education access, with some thinking, having exposure to other philosophies, etc. Can we say that a believer, if he believes, okay, fine. You need not be a rationally person using rationally.
This freedom of conscience.
Or in other words, Mr. Giri, let me just make a different dimension. If you say a religious practice is unique to the denomination, and therefore anyone who believes and is a part of the denomination is a believer and naturally will defer to it. If that argument holds, then will you agree that that will be contra to an inner debate in the denomination itself with regard to what ought to be a religious practice? And in this situation, what would be the role of the court? Let us say a person who is a believer comes to the court and challenges the belief of the denomination itself, which is being portrayed or canvassed as a religious practice of the denomination. He says, no, this has no ancient antiquity. This is not connected to the main core faith to which we all profess. And this has been put up for ABC reasons. In this situation, the will or will not a believer be in a position to challenge the denomination's claim of matters of religion?
Yes. Lord, there it could arise in two forms. One, I have my right of conscience. That would include a right to believe in God. And if I'm born in a religion, normally I would say that I have a faith in the religion in which I was born. But I still need not go to a temple. But I'm saying, I'm just giving an example. I still need not go to a temple to be a practicing Hindu. There are several places that way, several persons who probably do it that way. History also is replete with examples of that. But if I believe, if I go to a temple, then I go to a temple for the purpose of worship. If I go to the temple for the purpose of worship, then whatever is an integral part of the manner in which, my Lord, a deity is consecrated, a deity is worshipped, and a temple is maintained, is out of bounds for me, insofar as Article 25(1) is concerned, because this is part of the practice of my religion, which alone is protected under 25(1). A face-off between the right of a believer, a member of the denomination, and the denomination itself may not really be contemplated. If there is an inner churning out, within the denomination to see that any particular practice should be abandoned or modified, then, my Lord, it is a matter where,
So, Giri, we put it differently.
Yes,
Let us say
sorry,
a denomination consists of 100 persons,
yes,
correct? The 100%, they constitute a common belief.
yes,
So one stands up and say, I don't agree with this particular belief. So, as you rightly put it, subject to hearing. So one moment you question it, you stand apart, because adjudicating upon his right by a constitutional court under Article 25 and 26 would be a problem, because it is not your belief, but it's a belief of 99.
correct.
So that will be, see, that is protected under 25(1).
That's right.
And then you can even trace it under 26.
That's right.
So this is not available there here.
That's right. That's right.
Well, for example, we'll tell you, a temple is there, denomination, if that is ritual is being followed. There's no, you cannot get in and then say, don't do it.
Yeah.
But the same person, he can constitute at his home. He can exercise that right by deviating from that practice and do something else. That's a protection to him under 25(1).
That's right.
To that extent.
That's right. That's
Not with so long as it does not interfere with the common belief.
That's right.
Because 25(1) says person or persons.
That's right.
It constitutes a common belief.
That's right.
Then
If-
it's fine. So
that's
you who uphold your right, do not interfere in others' right. That's a very simplistic way of putting it.
I may not agree.
That's it.
If I don't agree, my Lord, I am entitled. And I have all the freedom to practice it in the manner in which I would like to. I can't do that by go to a public temple and then say that I'm questioning this. Either a temple or any other place of
What
worship.
would be the end then? A will say this practice, B will say that practice, C will be another
The
practice.
faith will be
You cannot-
thrown into disarray.
That is exactly for the reason we have 25(1).
So, Mr. Giri,
Sorry.
Mr. Giri,
Sorry.
putting an extreme example.
Yes, my Lord.
When we moved so far down the path of faith and belief, I go to a temple. My fundamental belief is that He is the Lord, He is my creator, He has created me, right? I go 100%, I'm totally devoted, absolutely nothing, pure in my heart. I go there. But there I'm told that because of your birth, of your lineage, or certain restriction, permanently you are not allowed to touch the deed. Now, will the Constitution not come in the rescue? The ultimate, there cannot be a difference between the creator and his creation to touch. You're right. How we do it for a certain period. Suppose I'm going, somebody throws mud or I fall in a mud. I'll clean myself. I have to be in a decent position to approach the deity in a pure way. That you can decide. Purification means that you have to accept, you have to take diksha, whatever it is. But then the permanent disability that I cannot touch my creator, I am a strongest believer of that particular, he is my creator. Will the Constitution not come? Because ultimately what you are projecting that he is the God, he is the creator. The creator will, creation will not be able to touch his creator? To what extent you limit it? When you call that, no, it is totally religious, somebody just because of birth, he cannot change. In this lifetime, he cannot change that position. So why only an Archika particular, why should the constitution not come and with it? And how does it define? Just because you think it is defined, why?
You're right.
Why
Your
cannot
lordships
we
are right.
just setting it to that extent? Let us not
Lordships are
the
right.
down the line.
Your lordships are right if
Discipline, but in permanent disqualification on
No.
the just basis that you,
it cannot.
something on which I have no control in future. I cannot change my position even if I want to.
Correct. Your lordships are saying if it is merely birth that constitutes a disqualification for a person, my lord, to become an archaka, to become a priest. In my respectful submission, that would be wrong, and that would be invalid. But if the religion has, my lord, if the religion has evolved in such a way,
Very probably it will come under 25(2)(b). There's no difficulty on that.
That's
It
correct.
will come under 25(2)(b).
yes,
It
yes,
becomes- it's a
Public
social
order.
Reform, social reform, no, not that. See, it's a
social reform.
reform. Or-
Maybe,
Argument
my lord, if
comes
the
from this side that no, Archakas, it's a valid practice. If has to be there, somebody, some particular, there's no difference. Even that particular caste, birth, by birthright, that has been argued from your side. It has been, you can't be contradictory argument.
no,
You have to balance the argument.
no, my lord, if the
religious,
state comes, sorry, my lord.
religious practice,
Yes,
particular, the practices associated with the particular deity involves certain agamas, certain way of worship, etc. One of which may be that persons who are qualified to do that worship only can do that worship. Therefore, a believer believes that only certain persons with qualifications can do that worship, and the benefit of that worship the believer also gets. It's not necessary in some Shiva temples, you see Om Namah Shivaya, you can put water on the lingam. In other temples, you cannot. There are various practices. In other temples, you are not permitted to touch because that is part of the what you call anushtanas or the practice or whatever. It is nothing
That's-
to do with untouchability as such.
my lord, that's why, my lord, in answer to what fell from you, lord.
These are the nuances.
These are the facets in the manner in which a mode of worship is effected. In answer to what fell from your lordships, if there is a complete ban on anybody becoming a priest, my lord, and priest by means, thus the person, my lord, who is instructed in the shastras as to how to conduct worship and how to worship, my lord, a deity. If there is a complete ban on any person becoming an archaka, becoming a priest, and then doing these sevas, as we call it, only by reason of birth, that, my lord, will be taken care of either by a 25(2)(b) legislation, or it will be taken care of by the faith itself.
Is it not elaborately discussed in Adi Saiva Sivacharya's case?
Yes.
That is the main aspect dealt with in that particular case. Faith is faith,
Faith is faith.
and practice something different. Practice is always something different, which is also based on faith.
My lord is referring to Justice Gogoi's judgment.
Just go through Adi Saiva Sivacharya's temple. Each and every aspect of this particular issue has been dealt
That's
with
right.
thoroughly.
That's right. That's right.
Yes.
Paragraph 34. It is submitted that in a subsequent judgment of this Honorable Court in Tilkayat, Shirur was sought to be explained by stating that there are religious practices which are essential and which are not, and that only the former would be entitled to the protection under 26(b) and not the latter. The court in Tilkayat also introduced a concept of the court exercising jurisdiction to determine whether a particular religious practice is essential or not. This approach adopted by this Honorable Court in Dargah Committee and Tilkayat incidentally has been referred to by the learned author Sirvai, 4th edition, volume 2. According to the learned author, this deviation from Shirur Mutt in both Dargah Committee and Tilkayat is obiter and only provides to substitute the court's opinion for that of the religious denomination as to what are the essential and non-essential parts of the religion. Then, my Lordship's issue number 5 is scope and extent of judicial review with regard to a religious practice as referred to in Article 25 of the Constitution of India. In Shirur Mutt, this Honorable Court went on to essentially uphold the autonomy of the religious denomination to determine what could be considered as an essential religious practice. The relevant para from the aforesaid judgment is extracted hereunder. Under Article 26b, therefore, a religious denomination or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold, and no outside authority. This would probably mean the court also has any jurisdiction to interfere with their decision in such matters. It is submitted that the aforementioned extract would suggest a complete autonomy for the religious denomination to determine whether any practice is religious or otherwise, religious or secular, my lord, it should be said. This Honorable Court did not deal with any distinction between an essential religious practice or otherwise. The distinction dealt with or referred to was between a religious practice and a secular one. This Honorable Court in Dargah Committee emphasized the need for judicial restraint while dealing with matters concerning religious practices. However, this court cautioned that the judicial interference must remain circumscribed and exercised sparingly, ensuring that only those persons which are clearly extraneous or non-essential fall outside the protective ambit of 26. My lord, this is what is mentioned in Dargah Committee. This is not my submission. While the core religious practices of a denomination continue to remain insulated from unnecessary judicial intervention. This Honorable Court in Tilkait went on to hold that there are religious practices which are essential and which are not, and the former would be entitled to the protection under 26b and not the latter. The court in Tilkait thus struck a different note from Shirur Mutt by introducing the concept to the court exercising jurisdiction to determine whether a particular religious practice is essential or not. This approach adopted in Tilkait came in for criticism by the learned author H.M. Sirvai. Lord, I'll just read the extracted portion. In Tilkait, Sri Govindalal ji, Justice Gajendra Gadkar again adverted to the rights under 25(1) and 26b and stated that if a matter was obviously secular and not religious, a court would be justified in rejecting its claim to be a religious practice as based on irrational consideration. It is submitted that the real question is whether the religious denomination looks upon it as an essential part of its religion. And however irrational it may appear to persons who do not share that religious belief, the view of the denomination must prevail, for it is not open to a court to describe as irrational that which is part of the denomination's religion. The actual decision in the case that the right to manage the property was a secular matter is correct. But that is because, as pointed out by Justice Mukherjee, Article 26b, when contrasted with Articles 26c and d, shows that matters of religious belief and practices are distinct and separate from the management of property of a religious denomination. The distinction between religious belief and practices which cannot be controlled, meaning controlled by the state, and the management of the property of a religious denomination which can be controlled to a limited extent, that is also controlled to a limited extent by the state, is recognized by the article itself and must be enforced. But this distinction is not relevant to the question whether a religious practice itself irrational or secular. My lord, if Shirur Mutt has been diluted to some extent, my lord, in Dargah Committee and in Tilkait and in certain other judgments which have taken the same path, then, my lord, the Shirur Committee must prevail. It's my respectful submission. That would also be an answer as to whether there could be a court interference at all. And if at all there is an interference, the interference is only for distinguishing a religious practice and a secular practice, and not to determine whether a religious practice is essential or not. That is not the domain of the court, my lord, is my respectful submission. Therefore, my lord, I say so in para 39. It is submitted that the court could be an arbiter on what is a religious practice and what is not. My lord, I should have said what is a religious practice and what is a secular practice. But then I make it clear, it is submitted that the court cannot embark upon an inquiry as to whether what is indisputably a religious practice is essential to the religion or not. That's not the province of the court. Whether you do it in a constitutional jurisdiction, my lord, or it comes about, my lord, in any other forum as such, that is not an area or a domain where the court might step in. My lord. It is submitted that an individual's right to freely practice and propagate his religion under 25(1) cannot run counter to the right of the same religious denomination to manage its own affairs of religion under 26(b), where therefore a religious practice provides for certain restrictions in the matter of expressions of faith and belief, extending to who could and who cannot offer prayers in a temple. A proponent of the faith cannot question the said religious practice of the said religious denomination and claim a right under 25(1) in antagonism to the right claimed by the denomination under 26(b). Only exception thereto could be where a religious practice could be questioned on public order, health, or morality. It is submitted that the right under 26(b) is not subsumed by the right under Article 25(1). In fact, the right of every individual belonging to a religious denomination under 25(1) will have to be in sync with the right claimed by the religious denomination under Article 26(b). It is submitted that this Honorable Court in Venkatramana Devaru, while upholding the right of the religious denomination under 26(b) in matters of religion, had observed that the law under 25(2)(b) would prevail over a right under 26(b). It is submitted that this principle is also made subject to a caveat, that this could only be in cases where the right under 26(b) would substantially reduce the right conferred under Article 25(2)(b). It is submitted that Venkatramana Devaru did not consider, and this, my lord, your lordships may kindly note, Venkatramana Devaru did not consider a face-off between a right claimed under 25(1) by a member of a religious denomination and the right of the denomination itself under 26(b). Then, my lord, 42, I just referred to two judgments, my lord. It is submitted that the concept of an essential religious practice would have different connotations. Yes, my lord, that is, I just referred to two judgments, my lord. In 43, I say, my lord, that I referred to.
You have summed up in 44.
Yes, my lord. I have summed up in 44, my lord. Thus, a religious practice which is integrally related to the characteristics of the deity would be completely captured by the right claimed by the religious denomination under Article 26(b). As a sequitur, no member of the Hindu religion could assert any right in antagonism to the said religious practice of the religious denomination. It is submitted that the principle that an individual's right under 25(1) to practice a religion cannot be in antagonism to the right of the religious denomination to manage the affairs of its religion, including an affirmation of the integral religious practice, would be applicable to all religions, though the facets of the right relatable to the characteristics of a deity may be applicable only to the Hindu religion. It is submitted that the Honorable Court in Shirur Mutt held that a question as to whether a practice is a religious practice or not will have to be determined with respect to the tenets of the religion itself. This facet of the dicta in Shirur Mutt was sought to be reiterated in Sheshammal and Commissioner of Police, that is the Ananda Margi's case as such. My lord, issue number 4 is regarding morality. My lord, I will not trouble your lordships. So much has been argued, my lord, on that.
It has been argued in detail.
It has been argued in detail, my lord. Therefore, I don't want to trouble your lordships on that also. My lord, so also regarding section of...
Issue number 6.
That's also regarding section of Hindus and classes.
I think
It has been argued in detail, my lord. There are so many other learned counsel, my lord, who are also waiting to argue.
Yeah, that's right.
I should restrict it to the absolute. My lord, I'll also skip para 53 and 54. I'll only, my lord, take your lordships to paragraph 55.
It's para 55.
Page 28, paragraph 55, that comes regarding issue 7, whether regarding the eligibility of a person not belonging to a religious denomination or religious group can question the practice of that religious denomination or religious group by filing a PIL. My lord, it is submitted that a person who does not belong to a religion or religious denomination cannot question the practice of that religious denomination or religious group by filing a public interest litigation. A brief reference to the articles in part 3 of the Constitution of India dealing with religious rights would be appropriate. The specific provisions in part 3 of the Constitution dealing with the freedom of religion are articles 25 and 26. Article 29 provides that no citizen shall be denied entry into educational institutions maintained by the state or receiving state aid on grounds of religion, race, must be caste, language, or any of them. Article 31 provides that all minorities, whether based on religion or language, shall have the right to administer or establish educational institutions of their choice. Article 16.5 provides that nothing in the article shall affect the operation of any law which provides that an incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. It is submitted that the impact of Articles 29 and 30 may not fall for the consideration of this Honorable Court in the present batch of cases. The aforementioned articles have no impact on Articles 25 or 26 of the Constitution. Article 16.5 is relevant only in the context of the right of a religious denomination to insist that a person belonging to the religion or a denomination thereof alone be permitted to occupy an office in connection with the office of any religion or denominational institution. A person who does not belong to religion A could not have the fundamental rights to claim that he is entitled to practice and profess the said religion. He may belong to religion B or C, and would therefore claim and assert the right to profess the religion in which he is born or the religion which he professes. But this Honorable Court is to consider a case where a person belonging to religion A seeks to practice religion B. There is no fundamental right available to such a person under Part 3 of the Constitution of India to either question the religious practice of the religion which he does not seek to practice, or a right emanating from any other part of the Constitution of India enabling him to do so. A public interest litigation, as laid down by this Honorable Court in numerous judgments, is taken up to consider the assertion of a right on behalf of a person who is disabled from doing so. At the same time, where a religious practice is in question, then a public interest litigation questioning the same would in effect be questioning the fundamental rights of the practitioners of that religion, where the practice of that religion is in question. This will never be entertained in a public interest litigation. No, my lord, there are other aspects on which, my lord, as I submitted, my lord, either my learned colleagues, my lord, who had argued before me had dealt with it, the solicitor had dealt with it, the additional solicitor general, my lord, Mr. Vaidyanathan, and then my lord, Dr. Dhawan, has also dealt with it. It will probably be dealt with this also, my lord. In my respectful submission, according to me, the right under, I'll just sum up, my lord, saying that the right under Article, just 1 minute, the right under Article 25(1), constitutional right, is to practice the religion which I profess. It is rested on the inalienable principle that I can, if I want to, when I practice the religion, I should be a believer. If I am a believer, then I'm a believer in the core principles of the religion which I profess and practice. I cannot claim a right under 25(1) in derogation or in antagonism to the core beliefs of the religion which I profess and which I seek to practice. I cannot do it in antagonism to that. And the right under 25(1), even for entry, will have to be in sync with the core principles of this. And to that extent, my lord, when your lordship say that the right under 25(1) is to be protected, and obviously it has to be protected. It cannot be, it has to be in sync with, when I come to the context in question, it has to be in sync with the characteristics of the deity, which is an integral part of the mode of worship that is protected, adumbrated, and practiced, my lord, by the faith in which I believe in, my lord. This is essentially what I wanted to say, my lord.
Thank you, Mr. Giri. Thank you.
I'm deeply grateful to you, Lord. I'm deeply grateful.
Just a minute, please. Mr. Gopal, would you like to argue right now, or you want them to finish the review petitioner? No, we will go by, if you want to, you are most welcome. You can start. We will hear you.
Friend wants to conclude, my lord, I yield to him. I'll then take over as soon as.
Or because they are probably supporting the review petitioners, they can briefly sum up.
May I set out my position because I'm sitting here? My lord, my position is on a point of principle. As a matter of legal construction, I have difficulty with the majority opinion, Sabarimala case, as a matter of law. And my lord, these questions will have to be first answered in my submission in an abstract manner,
Exactly.
without reference, my lord, to, shall we say, the facts of any particular case.
I agree.
And my lord, they do require some degree of reflection, rumination, which I suppose, my lord, in the course of my submissions, we will do it
No, no,
collectively.
it's not.
But it does require, my lord, extreme thought, because we are dealing with very profound areas of personal faith. We are also dealing with collective faith. And, my lord, above all, which we should not forget, we are dealing with all religions in this country.
Mr. Gopal, we would like to hear you in detail, and after let them supplement what has been argued, and then we'll request you to
Certainly.
submit it. Mr. Dwivedi, you immediate after Mr. Gopal? Oh, all right. Yes, Mr.
Yes.
I'll argue after. I'm for one of the review petitioners. As the president of.
We will hear all of you.
Yes, I will say that with the review petitioners, I'll complete my submissions. But both Mr. Gopal Subramaniam and Mr. Dwivedi will be arguing after that on a wider compass of other religions. So I will complete after Mr.
Yes, after Mr.
We
Sankaran,
will hear you also, Mr. Sundaram. We will hear you.
after Mr. Sankaran, I'll proceed.
Mr. Dwivedi, please.
We will hear all of you, but only request you, please, there is no need to repeat.
Repeat.
Like Mr. Giri very fairly skipped some of the arguments, because rightly so, earlier those have been elaborately argued. So just briefly, please sum up your points.
I'm strictly following one of the seniority order. I'll go after Mr. Dwivedi.
It's after
No,
Mr.
not
Sankaran,
now.
I'll submit. I'm on 901.2.
Mr. Gopal,
Yes, please. Well, I think your lordships will be happy to know I have a one-page note, which I'm handing up. And usually in these constitution benches, which, because I've played a part in that book, I hand up copies to the judges. So if your lordships wouldn't mind, I'm just going to refer to this, nothing else, only these two.
in the soft copy,
Yes.
just indicate where it is there so that we can note
Yes.
down.
In the soft copy, it's at 1.1, page 863.
863.
Page
Yes.
863 of 1.1. That's also a two-page answer to the questions, my lords, broadly. I believe, and I'm completely in accord with Mr. Subramaniam, that we shouldn't be looking at the facts of
What is the
individual.
volume?
Yes,
Once again, one volume?
volume 1.1, page
862.
863.
That's it.
863, but your lordship may just ignore that for the time being. I'm just going to only deal with this, my lords. So like I was saying, my lords, I'm completely in accord with Mr. Subramaniam. We must look at it on a completely broader plane than looking at it from the point of view of Sabrimala. I am appearing for the review petitioner in Sabrimala and some others. We are devotees there, plus other religious groups. I have 2 intervention applications also. But I think when your lordships are looking at it from the perspective of 9 judges, we are transporting ourselves back to 1950 effectively. And all the judgments that have come before would possibly give some guidance, would give a template about what we are actually grappling with. So if your lordships don't mind, the approach that I am adopting is as follows. The first is to look at the larger scheme of part 3 of the Constitution in the backdrop of the religions and the denominations that populate this vast nation, this civilization, as Dr. Dhawan said. That's relevant. The second is bearing in mind what specifically are the religious practices and issues that we constantly see. We have been seeing a lot about temple entry because that is an issue in one case in this batch. There are other cases also in this batch looking at different aspects. One is looking at mutilation, the other is looking at Parsi woman marrying outside her community if she's allowed entry into the fire temple of the Agyari. There are different issues that keep coming at every stage. We have had the issue with the hijab in schools. So there are multiple issues which will arise in a country which is so rich in its culture and so rich in the practices that you have. All of this will be encompassed in it. So it's in that backdrop, and in the backdrop particularly of part 3, I was wondering if we could explore how 25 and 26 and its interaction lies and what flows from it. This is 2 pages, my lords, which I've handed up back to back. So if your lordships will kindly take that. On the front is Articles 25 and 26. I've set that out and I've highlighted the, just give copies to the others. And I've highlighted color-coded, so your lordships can see what I feel requires emphasis. But just before that, just for a minute, if your lordship will take the Constitution,
There's a certain scheme I wanted your lordships to go through as far as part 3 is concerned. If your lordships will indulge me in coming to part 3 and looking at some specific provisions, my lords. I think also to partly answer some of the questions that fell from the court. Article 13, my lords, if we can start with. Ladyship, Justice Nagaratna on the first day had asked, what is the scope of this existing law?
Existing law is defined.
Correct. It's
In
defined.
Article 366(10).
Correct. In 366(10). So is also continuance of laws in force under Article 372. As also the expression laws in force, which is used in Article 13, Clause 3. Right, Manoj? Now, there is at least one judgment in the 1950s which specifically says laws in force and existing law effectively means the same thing. It will be there in my written note. There is a judgment of your lordship which says so. I don't believe too much flows from it, except perhaps in a narrow area where custom and usage, the question may arise. If you see Article 13, subclause 3, in this article, unless the context otherwise requires, law, and I'm looking at law, includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage.
Article?
13, 1-3. It should be at page 11. 13, subclause 3, the definition of law, which includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage, having in the territory of India the force of law. And B, laws in force includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. Now, as your ladyship rightly said, 366 subclause 10 defines existing law, and 372 also your lordships may see at whatever time.
366(10).
Yes,
Custom and usage is not included.
it's not expressly.
It's always by an authority made law.
That is correct. That is correct. That is
15.
That is correct. So there is a mismatch in the language of laws in force here, as well as 366(10). But for a minute, if your lordships will see 372, Article 372, which is page 414,
Yes.
which deals with continuance in force of existing laws and their adaptation, notwithstanding the repeal by this constitution of the enactments referred to in Article 395, but subject to the other provisions of this constitution, all the laws in force in the territory of India. Your lordships note the laws in force phrase is used. But again, once again, and this is where I think some problems may arise, laws in force definition in Article 13(3) is only for the purposes of that article. Only for the purposes of 13. It doesn't appear that it would apply to where the expression used outside of part 3. But this uses the words laws in force in the territory of India immediately before the commencement of the constitution shall continue in force therein until altered or repealed, etc., etc. And for the purpose of bringing the provisions of any law in force in the territory of India into accord with the provisions of this constitution, the president may by order make such adaptations and modifications, etc., etc. And explanation 1, if your lordships will come to, just after 3, the expression law in force in this article shall include a law passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that it or parts of it may not then be in operation either at all or in particular areas. Now, just coming back to part 3 for a minute. After 13, if you see where the rights actually start in 14, these words are important for two aspects of what we have been debating for the last several days. One is with reference to constitutional morality, with reference to morality and the expression it uses. And second, about the operation of fundamental rights. 25 is admittedly an individual right. 26 is admittedly a group right, a denominational right. The question is, who are these rights against? Which is why the questions again came on the first day with reference to vertical and horizontal. Just see Article 14, my lords. 14 says, the state shall not deny to any person equality before the law, etc., etc. So the state shall not deny. So it's couched in negative terms and the obligation is cast not on individual temples or denominations or groups, but on the state. So this is clearly a vertical right. 15.1, 15.2, interesting to note how it's phrased. 15.1 says, the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Please note, Manoj, sex is used here, but you'll find later when we come to 29.30, it's not used there. So based on gender, you can have classification there. You can't have it here. And who can't have it? The state can't have it. But other individuals can. If there's a private company, for example, and my company, I recruit only women in employment, I'm entitled to it under the Constitution. Nobody can raise a question. Now, if that question cannot be raised against a private company, where does a religion or a denomination stand in this scheme of state, then corporation, educational institution, religious denomination?
Kerala rules were challenged.
Correct.
Rule 3B is it is a subordinate legislation.
That is correct. That is correct.
Kerala Act.
Yes, but that is the Temple Entry Act. Now, in the Temple Entry Act, rather than allowing the entry of those women in that age group, the Act bars it. Correct. So it was
Based on
an indirect
custom and-
challenge to that. Yes, I'm sorry.
Custom and usage.
Based on custom and usage. The question is whether a right by an individual, which is what was, I think, being discussed just with Justice Giri just now, Mr. Giri just now, the right that is being agitated, who can it be agitated by? And more importantly, against whom can it be agitated? If you see 15.2 for a minute now, which is in contrast with both 14 and 15.1, no citizen shall, state doesn't come into the picture here, no citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. So 2B is with reference to funds which are of the state and used for the public. But A is not. So if the access to restaurants, if the access to hotels, places of public entertainment and shops, there is discrimination on any of those grounds, that discrimination, if it's not being done by something which is run by the state, it's being done by private individuals, corporations, the citizen is given that right under 15.2. So it becomes a horizontal right. Which is why the distinction between the vertical and horizontal right comes into play when we look at the opening words of 25.1a. Because 25.1a says not only public order, health, and morality, but also other provisions of this part. It's not all provisions of this part that 25 has to worry about then. It's the places where horizontal rights are being agitated, which is why identifying what those provisions are becomes critical, which is why I'm undertaking this exercise now. If I see 15.3, yes, I'm grateful to Shutanjay. He says 15.2 doesn't say places of religious worship. It doesn't say that.
That has been argued by Mr. Vaidyanathan.
Yes, so I'm not going into.
Vaidyanathan indicated the distinction.
Yes, so I'm not going into. I'm just mentioning
In
it.
the enabling
Yes.
power of 25(2)(b)
Yes,
of entry.
correct. But I don't want to revisit anyhow. The solicitor says it was introduced and deleted. 15.3 says nothing in this article shall prevent the state from making any special provision for women and children. And this not preventing the state, which you find in 25.2, is an expression which is used some 60 times across the Constitution, showing that really, rather than empowering, all it says is, look, this is not an obstacle for you. It's a message to the state that when you make this law, this will not come in the way. Therefore, in 15.4, in 15.5, in 15.6, the same expression is used again and again. Now, if you come for a minute, my lords, to 15.6 or 15.5 end and 15.6, because I have an argument on this as well. When it's talking about reservations, at the fag end of 15.5, your lordships will find that it's whether aided or unaided, this is at the end of 15.5, whether aided or unaided by the state other than minority educational institutions referred to in clause 1 of Article 30. So when reservations are being provided, minority institutions under 30 are excluded by the Constitution. I'll explain why I'm mentioning this, but I'm drawing your lordship's attention to this. It's similar in 16(6) as well, 15(6) as well. 16 is also couched in the same manner. There are no horizontal rights there. It's again nothing in this article, nothing in this article, and with reference to public employment, which your lordships are aware of. Now, 17 is a central aspect of the argument. Abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. It's very strong terms to be used in a constitution. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. Now, this is clearly a horizontal right. And if for a minute your lordships will indulge me, after 17, I'm just leaping to 23 and 24 to illustrate what the other horizontal rights are.
Mr. Gopal, 19.
I'll come back to 19. I just wanted to read these three together. 17, 23, 24. I'll come back to 19. Just for a minute.
You must also keep in mind.
Yes.
The expression untouchability is within inverted commas.
Absolutely.
So what the constitution framers had in mind
Yes.
when it is untouchability is
Yes.
bearing in mind the historical
Absolutely. No
aspect
question.
and the
No question.
social,
Yes.
you see,
Absolutely.
practice, so to say.
Absolutely. Absolutely.
This is what they had in mind. They made it a.
There's no question about it.
fundamental right.
There's no question. In fact, this
Therefore, it is
is-
not any kind of, you see, prevention or whatever.
It's not. It's very clearly understood at that time. And that's why Article 17 has to be read not in an isolated fashion. It has to be read along with the 25(2)(b, making it clear for entry. It has to be read with the provisions in 331 onwards, which specifically provides for a commission. It provided for the only reservations that we had in the country in 1950 as a right, as an assurance, was the rights which were available to the SC, STs and the Anglo-Indians in the legislatures and parliament. That was only constitutional assurance. Reservations for education and reservation for employment was not a constitutional assurance. It was enabled by 15 and 16 if the state decides to make that law. But the constitutional assurance was because we had that in mind. The reason I mentioned this, and I'm grateful to leadership for that observation about the inverted commas, is because one of the arguments that we have had in the earlier Sabrimala round was to say that this untouchability could possibly include anybody who is excluded from any particular practice. Absolutely not. It is only and only for those who are known as the scheduled caste today. The schedules, in fact, we had occasion to assist your lordships on this earlier, comes from the 1935 Government of India Act, not any schedules to this constitution, where actually each of the castes, which subsequently came in the presidential order, were listed. That's why it's referred to as scheduled castes and scheduled tribes. Now, I'm sorry, my lords. So the scheduled castes and their right here that this so-called taint which existed all this while is completely abolished, and more importantly, any disability arising from it goes, means that it is something which has to be honored by every individual, every entity, no matter who or what it is. There is no question of any classification, exclusion on this ground. There is absolutely no ground about that.
It's a horizontal right.
It is absolutely a horizontal right. The reason why I want to read 17, 23 and 24 together before coming to 19 is because these, in addition to 15(2), are the horizontal rights we have. Just for a minute, 23, if I may. Traffic in human beings and begar and other similar forms of forced labor are prohibited. Again, strong phraseology. I'm sorry, this should be page 39, Article 23. And any contravention in this provision shall be an offense punishable in accordance with law. So 17 and 23 are creating offenses in the Constitution, not waiting for a penal code to come along. 2, nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service, the state shall not make any discrimination on grounds only of religion, race, caste, or class, or any of them. A conscription, etc. would come under this. 24. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. So these are absolute bars. Now, to link these four, or in fact, the latter three, if I can take your lordship just for a minute to Article 35, all part of part 3. And Article 35 starts with notwithstanding anything in this constitution. This is page 55. 35A, notwithstanding anything in this constitution, Parliament shall have, and the legislature of a state shall not have, power to make laws. Just see 2, my lord, small Roman 2. For prescribing punishment for those acts which are declared to be offenses under this part. So they wanted Parliament to make that law because the offense is recognized, but the punishment is not prescribed. The procedure is not prescribed. None of that is there. And Parliament shall, as soon as may be, after the commencement of this constitution, make laws for prescribing punishment for the acts referred to in subclause 2, small subclause 2. Now, the reason why I mentioned this, my lords, is the Protection of Human Rights Act. It had an earlier name, the Untouchability Offences Act 1955. As soon as maybe it was 1955 when that act came in. That act is at the moment in volume 4.1, page 450. It's worth reading specifically on this point because it deals with religious and religious denomination. So just for a minute, if your lordships don't mind, I'll just refer to it. So it's at, I'll just mention volume 4.1, page 450. Now, at that specific definition, section 2D, it deals with places of public entertainment, etc. But 2D specifically defines place of public worship. Allow me to read it. Place of public worship means, it's volume 4.1, page 450. At 451. Volume, it's on the screen, my lords, if your lordship see.
Please put that at.
They're on the screen.
Yeah, it's on the screen. So 2D at page 451.
This is volume 4.
4.1.
Place of public worship.
Place of public worship, that's it. Means a place, by whatever name known, which is used as a place of public religious worship or which is dedicated generally to or is used generally by persons professing any religion or belonging to any religious denomination or any section thereof, thereby the phrases in 26 are there, for the performance of any religious service or for offering prayers therein, and includes, please note this, all lands and subsidiary shrines appurtenant or attached to any such place, a privately owned place of worship which is in fact allowed by the owner thereof to be used as a place of public worship. And 3, such land or subsidiary shrine appurtenant to such privately owned place of worship as is allowed by the owner thereof to be used as a place of public religious worship. And then, my lords, section 3, next page, 452, punishment for enforcing religious disabilities. Sections 3 and 4 are critical. Whoever on the ground of untouchability, once again inverted commas, prevents any person from entering any place of public worship which is open to other persons professing the same religion. Please note, same religion, or any section thereof as such person, or from worshipping or offering prayers or performing any religious service in any place of public worship or bathing in or using the waters of any sacred tank, well, spring or watercourse, river or lake, or bathing at any ghat of such tank. This could include the Ganges, etc. Watercourse, river or lake in the same manner and to the same extent as is permissible to other persons professing the same religion or any section thereof as such person, shall be punishable with the term, etc., etc. Punishment is there. And then the explanation. For the purpose of this section and section 4, persons professing Buddhist, Sikh, Jaina religion, or persons professing the Hindu religion in any of its forms or developments. They've used the word development when they could have used denominations, including Veerashaivas, Lingayats, Adivasis, followers of Brahmo, Prarthana, Arya Samaj, and the Swaminarayan Sampradaya, shall be deemed to be Hindus. The section 4 is dealing with social disabilities and makes it clear in the explanation at the very bottom of page 453 that for the purpose of this section, enforcement of any disability includes any discrimination on the ground of untouchability. Justice Antonin Scalia, who the learned Solicitor General had referred to, had come for a conference in the mid-1990s to Delhi, in fact. And one of his lectures when asked, what is it that you believe America has done legislatively better than India? He said it's the Civil Rights Act. He believed, and perhaps that is true, that the problem is that assuring to every individual the rights that when you have a constitution which has fraternity at the front of it, the fact that you don't have a comprehensive Civil Rights Act which takes care of all these issues vis-a-vis all communities and all castes is perhaps a failing of the state. Now, I'll come back. Now, the reason why I showed this, Manoj, is to show that 17, 23, 24, along with 15.2 are horizontal rights. There aren't, from my reading at least, any other horizontal rights that I could find in the Constitution. This becomes relevant for the interpretation of 25. But for a minute, as my Lord Justice Bagchi mentioned, may I take you to Article 19? So 19, my lords, provides for A, freedom of speech and expression. And I'm drawing your lordship's attention to C, which is to form associations or unions or cooperative societies. The reason I'm looking at A and C is for two reasons. One, A and C are controlled by 19.2 and 19.4. 19.2 and 19.4 are the two clauses, the two controlling clauses, which use the word morality. There is an application of mind by the framers, by the founding mothers, specifically to employ different controlling phrases for each of the clauses in 2, 3, 4, 5, and 6. This becomes relevant when we look at the controlling phrases used in 25 and a part of it in 26. It is deliberate because when you look at 19, we understand what they were thinking and what direction they were taking. They were thinking of the forms of expression that a person who wants to live freely would have. He would first want to speak and express himself. So that is protected by 1A. 2 is to assemble peaceably. So you meet. C provides for associations or unions, or now cooperative society. So you organize yourself. The way I see it as far as religion is concerned, Article 25(1) gives me the right to believe.
And
Or
profess also.
Profess, practice, propagate. But for profess,
How will you, Mr. Gopal?
yes,
Read
yes,
19(1)(a)
yes,
expression
yes,
with the word profess
yes.
any religion in 25(1).
So the way I would read it is this. The
Will you
19(1)(a)
consider
right,
19(1)(a) expression
yes,
to be a general law,
yes,
whereas 25(1)
yes,
pertaining to professing religion,
yes,
a special law, and
yes,
thereby any professing of religion should be governed by 25(1)
yes.
and not under the generic ambit of 19(1)(a).
That is absolutely,
Because
yes,
after all, every professing of religion is an
yes,
outward expression of an individual.
absolutely, it is.
So
So
can we proceed?
yes,
Why I ask this question is because of Mr. Giri's
yes,
contention of individual
yes,
being completely emasculated, even to question a religious practice which is propped up
yes,
by his denomination.
yes,
I say
correct.
I am a granular in part
Yes,
of the denomination,
yes,
and the denomination professes as a religious practice, which I feel
yes,
runs counter to the tenet of the very faith.
yes,
Now, the arguments advanced till now is I can't because I'm a believer.
yes,
That may be good on a generic moral or emotional plane.
yes,
But when you come to assertion of a legal or constitutional rights,
yes,
will 25(1) get color from 19(1)(a)
yes,
and thereby must be read harmoniously with 26(b) and not
absolutely,
subordinated.
absolutely. So let me just explain as a response. When birth takes place, an expression starts. The expression is in multiple forms, only one of which is dealing with faith or dealing with religion. If I want to believe, I could easily want to be an agnostic or an atheist, in which case I don't want to believe. But still, my right,
Not an atheist does believe. He does not believe in
So-
the idea that there is a maker
correct.
who has
So,
created that.
Actually, the atheist would be a strong opposer of it, and agnostic would say, look, it doesn't trouble me in the least, but I'm not signing up for this. But either way, all these three will, sorry,
Atheist doesn't believe in the existence of God.
yes,
Agnostic believes in a higher strength, or what you say, a higher, some kind of a form or something.
I'm not sure about that last bit.
Agnostic doesn't believe
Yes.
in God, but
Yes.
he believes in a higher power.
Yes,
Ultimately,
Yes.
whoever it is, all are believers. Either they believe no God or they believe higher God. or
Perhaps.
higher,
perhaps,
power.
but what I'm saying is,
Believe in idols or something.
Correct.
All
So-
are believers.
what I'm saying is for that
Yes.
for that spiritual aspect, let me put it like that, for the spiritual aspect of the expression of the spirit,
God will.
I would, I'm sorry. Yes, so for the spiritual aspect of a believer, not a nihilist, I would say that the right would come from 25:1. But that is the spiritual side of me. But if I want to express myself in different fashions, whether I want to express myself in a public pulpit, or if I want to be in a debate, or if I want to write in a newspaper, all of that comes from 19:1A. But to answer your lordship's question, if I am a person who has initially embraced a particular faith, and then I find that there's some practice which is abhorrent, and I want a correction of that faith, if I want to express myself to correct that faith, that is not an expression of 25:1, because 25:1 is a take it or leave it provision. 25:1 says, for me to propagate or practice that religion as it stands, you have that right under 25. But if there is a dissent, if there is a course correction that I want to agitate, I use my 19:1A right, but I'm not using it against the state. I hope I'm making myself clear.
I can use
It's not a right available to me against my religion.
19:1A,
Yes.
as you said,
Yes.
is a horizontal right.
Yes.
And therefore,
No, 19:1A in my view would not be a horizontal right.
is not a horizontal.
I'm not saying that. I don't think it's a horizontal right. Because if allow me to read it.
How-
It says all citizens should.
Kaushal Kishore has said it's a horizontal right.
Yes, but
We have to look into Kaushal.
now the problem with that is if I say it's a horizontal right, it can be directly enforced by somebody who claims that look,
Let's say
there's
there
a
is
while.
hate speech
Yes.
against an individual.
And if there's no
Can't
law.
he go to the court
Yes.
and enforce his fundamental right?
In my view, 19.2 gives the answer to that. 19.2 gives certain controls and those controls alone. Incitement, libel and defamation and slander, integrity and sovereignty of the country. Those are the grounds.
They are,
If there is some, yes,
are not in the very nature of defamation.
yes,
It shows
Yes.
that 19:1A
Yes.
is not directed against the state
yes.
or not enforceable against the state or by the state.
The problem
Is
is,
definitely
Yes.
enforceable
yes.
against anyone who suffers defamation,
So let me give an example, Malad.
suffers injury.
I,
Because
I
of
want to
the
give you a-
expression by.
I want to give your lordships an example. I'm a school student. I stand up and keep interrupting the class saying I have a 19:1A right. It's my horizontal right. I'm expressing it. Is this wrong for the teacher to say I'm throwing you out of class because you're disrupting it? Can the student come back and say my 19:1A right has been violated? My answer is no. I'm clear about this. There is no horizontal right available for that person under the Constitution. There may be different disciplinary regimes, but those disciplinary regimes cannot be challenged by saying that my 19:1A right has been violated. Because there are spaces within which discipline is required, speech of this sort cannot in fact be utilized. Offices wouldn't be able to function. Most places where you require some level of restraint wouldn't be able to function. In fact, I mean, I know this as a personal tale. The Official Secrets Act provides that civil servants, if they speak out openly, honestly, and truthfully about what is happening in their offices, they are not protected by 19:1A. Because the Official Secrets Act says that any action of this sort can
Because of the reasonable restriction of security.
it can't be a reasonable restriction unless it
This
is
is a
on
re-
sovereignty, integrity, or those grounds.
Security of the.
If I'm talking about a minister having taken a bribe,
Legislative competence
yes,
whether the restriction is reasonable or not is the principles of proportionality. Like
Yes.
a student asking a question,
Yes,
to the extent the student disrupts
yes,
to the right of expression of the teacher
Yes.
is a question of proportionality, not enforceability.
but
There's
it
a
would,
difference between proportionality and enforceability.
well, the
The
reason,
teacher cannot stop all students.
yes.
But again, the student cannot stop the teacher. So whenever such a situation comes before us, we apply the test of proportionality.
Well,
But Mr. Gopal, please
Yes.
examine it.
Yes.
Whether enforceability comes into question. Enforceability, definitely it's a horizontal right.
My lords, if I may, in Ramesh Thapar, which is one of the early cases of this court, when the very same question arose
have gone
about the
far
circulation.
beyond
No,
Ramesh.
there's a reason. There is a reason why I'm saying that.
Ramesh Thapar.
In Ramesh Thapar, the reason why, no, allow me to complete my. In Ramesh Thapar, the reason why the law was struck down was simply because public order was not there as a ground in 1902. So they had to come up with the First Amendment to the Constitution, bringing it in as a ground and bringing in the word reasonable as well. Now, if that is the strictness that we attach to the adjudication of this provision, I ask myself, if there is an officer in government who says, look, this minister has been taking a bribe, he's corrupt, etc., it's not defamatory or slanderous. It doesn't fall under any of these grounds.
We understand. You are saying on right under 19(1)(a).
Yeah.
But Mr. Gopal, your time will be over by 1 o'clock.
No, Malad, you're giving a timeline to me for the first time. It's not been
Yes,
enforced so far.
45, we have given you 55 minutes.
Malad, to be fair, I'm not trying to repeat anything. I'm just
No,
trying
no,
to
ab-
take your
absolutely
lordships
not.
through a.
We are not saying that you are repeating.
Sorry. I don't mean to take any more time than is absolutely necessary. Now, it's in this context now, if I can take your lordships to the one page which I had handed up. And I want to give your lordships what I believe is the appropriate interpretation. And this is not on behalf of the Sabrimala devotees, etc. I believe 9 judges have convened to interpret this after 75 years. We have to ensure that it goes on for a while, and we give you the assistance no matter what the client wishes. Now, Article 25, we have marked subject to public order, morality, and health. Morality, as your lordships have seen, comes in 1902 and 1904. The only point that I was coming to was you first express yourself, then you decide to assemble, then you form an association. So if you want to formalize a religion, you will first express under 25(1)(a). You will then form, if you have to form a trust or a society or whatever it is, for the purposes of implementing your rights with reference to the religion, of setting up a temple, of setting up a charity, of setting up a school, you will do that under 19(1)(c). You will first exercise your right under 19(1)(c) for that purpose. And then we go back to 26, 25, whichever will apply. Now, public order, morality, and health, and to the other provisions of this part is the phrase used here. The phrase used in 26 is subject to public order, morality, and health. Now, I must tell your lordships, I have learnt a lot more about this case in the last 5 days, hearing all my friends arguing it, and I have had to vex myself repeatedly on what could be the best way to interpret and harmonize these two provisions. My view is as follows, and I'll just explain. When the words other provisions of this part is used in 25, the other provisions which are being referred to are the horizontal provisions of part 3. Therefore, the other provisions to which it be subject would be 15(2), 17, 23, and 24. I hope I'm making myself clear. That is what I believe is the interpretation of other provisions of this part. The question, secondly, is with reference to morality. Now, I disagree with the solicitor's formulation because your lordships must know there are 3 sets of arguments before your lordships. One is on behalf of the government and the Travancore Devasam Board. I must tell your lordships, in all honesty, Dr. Singhvi has been representing them. They have been going from one end to the other. They've taken different views at various stages in this litigation from the beginning. Now, governments, boards, etc., boards are creatures of the government, they want to control. So their interpretation is going to be very wide with reference to 25(2)(b) and its application to 26. They are going to say it applies. They are going to say, yes, we can make laws on virtually everything. But suddenly when it comes to judicial review, there's a screeching halt. No, but you please keep your review within a narrow passage. We won't go the whole hog on it. So that is one set of arguments that your lordships have heard, throwing constitutional morality overboard and saying, let's go with public or social morality, which we will determine. We are the elected representatives of the people. That's section 1. Segment 2 are the arguments that Mr. Vaidyanathan, Mr. Giri, me, Sai Deepak, etc. are taking, which is on behalf of temple management, tantris, etc., devotees, etc. Where we are saying, look, 26 is not meant to be controlled by 25(2)(b). It is not meant to be controlled. It doesn't anyway do violence to the entry provision with reference to the Article 17 covered people or anybody else. It will not, and I'll explain why. That's the second set of arguments, saying that therefore, we believe that the scope for making law to restrict our rights is extremely limited and narrow. The scope of judicial review, in our view, is open wherever that issue arises and a law is made and there is a fault found with that law. Obviously, all the grounds which are available to challenge a law is available, so we can't run away from that. The only point we take is, can you come first as a non-member of a community, second in a public interest litigation, and third agitating a fundamental right to say course corrections are required? Is that possible? We believe no. And we believe,
Because subject to other provisions of this part
yes,
would include Article 26.
yes, 100%.
Subject to
100%.
other provisions of this part means
100%.
don't look at only
Correct.
14, 15.
Correct. Exactly.
Article 26 is also there.
Absolutely. Which is why between 25 and 26, there's no question that 26 stands above. And Justice Bagchi had mentioned, I think 2 days ago, that what is the significance of the absence of the words subject to in Article 26?
So I'm not on that.
No,
What I meant was,
yes,
subject to other provisions of this part
correct.
means 25(1) is, you can argue that
Yes.
25(1) is also subject to 26.
I agree. That is
That's
why
how
I'm
I'm
saying,
looking at it.
my lords, I'm completely in agreement. I'm saying the corollary to this, to support what leadership is saying, is the fact that in 26, similar words are not there. Otherwise, a confusion could have arisen where in 26, if they said that 25(2), which provides for the state to make the laws on all these grounds, would equally apply, they could have said subject to 25(2), 26 will have these limitations. They didn't say that. They didn't say notwithstanding. They didn't use any of the tools which is available to them and which are readily employed throughout the Constitution. It's not used. Now, the third segment of arguments is what my friends are taking. I'm presuming what they are saying is that the scope of state control is substantial and the scope of judicial review is substantial. So everything can be controlled. 26 will be controlled by 25(2), and therefore all rights of the fundamental rights chapter will apply, not only the horizontal rights as I'm arguing. I hope I'm making myself clear. These are three segments of argument. So if your lordships feel we have heard the petitioners for a while and we find discord and disagreement, it's because we're not all really petitioners. Mr. Mehta is clearly appearing for the Union of India with a completely different cake to bake. We are not them. They are attempting to control us. We are objecting to it. I hope I'm making that position clear. I think we are all ad item on that position. Now, coming to this other provisions of this part, I just wanted to make, and once again, that submission, that 26, therefore, is not controlled at all by 25. 26 stands alone. If 26 stands alone, the first question that is going to be asked is, 25(2)(b) talks about entry and talks about entry of all sections. The exact words are classes and sections of Hindus to Hindu religious institutions of a public character. How is it then that a denomination can stand up and say, I can exclude Dalits? A denomination can never say that. And let me tell you the reason why. Because the morality that is referred to at the top, where it says subject to public order, morality and health, the morality that arises from the Constitution is that what the Constitution proscribes is clearly immoral. There's no question about it. So the religious denomination, if it attempts even remotely, if any religious denomination that daft to try that in this day and age, it is immediately controllable by the law that is made or by the state using its executive power to control, saying that the morality aspect is being offended because 17, 23, 24 provide the protections to those communities and groups who have been oppressed, and that oppression has led to us creating a constitutional offense. I hope I'm making myself clear. That provision squarely applies, because this is a question that I anticipate against me, that if you're interpreting it like this, morality is used in 25 as well. I'm sorry. No, morality is,
Please repeat.
yeah, morality is used in 25 as well. So if morality is used in 26 and 25, 25 expressly says entry, 26 doesn't. Your argument is that morality will anyway frown on this kind of an exclusion and entry. Why was the need for the constitution to have a 26 2b's latter part, 25 2b's latter part? What was the need for the constitution to have that? The need was because a law has to be made specifically providing for, and I want you, Lordship, to just see what the phrase is. Providing for nothing will affect the operation of existing law or prevent the state from making any law, providing for social welfare and reform, or, and I agree with Mr. Mehta's formulation, this is distinct. Social welfare and reform is one thing. It applies to all communities and religions. Or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. I have two responses to this, and I'll explain what it is. Take a Dalit Christian. I'm sorry.
Effectuation
Yes,
of what is stated in Article 17.
exactly. It's an effectuation, it's a clarification. It makes it abundantly clear that there is no question of a religion excluding these sections or groups at all. Now, again, please note that they have singularly drawn out one religion among all the religions that they knew of. They took the Hindu religion. Of course, there's a DMA explanation regarding.
Already argued it.
No, but I have a different take on that. When you take a specific religion and you put it there, clearly it's not meant to be read in the widest form possible. In a secular constitution, you must read it in the narrowest way possible. Because if you read it in the widest way possible, sections and classes of, classes and sections of Hindus can be read as they, my friends, seek to do, to include women and their right of entry into temples. I'm giving an example of women. It can be any other group or class. If that were to be done and permitted, the question is, what would the Muslim woman say, or the Parsi woman say, or the Christian woman say? I don't have that right. You're not opening it up for me. Similarly, what would a Dalit Christian say? Because we do have those. In all of those, because you are opening it up only for the Hindu community, because we have historical wrongdoing and prejudice regarding the Hindu community and the untouchability group, we ensure by virtue of this clause that Hindus, we are making it clear to you, you're not going to exclude these sections and classes from entry into your temples. But equally, linking it to 17, equally making it clear that, look, the sections and classes are that limited. In my view, the section classes here are only those covered by Article 17. The reason why they use both phrases is, in classes, it's really the castes. In Indrasani, you've made it clear that caste is a starting point for classes under the backward classes. So those lists would be covered by classes. Sections would possibly mean occupations, where you're not able to define them by specific community names, but you know by their occupation that they fall within that same Article 17 bucket, because the earlier Kaka Kalelkar Commission in 1958 and then the Mandal Commission in 1979 had both gone into these communities in detail and said the easiest way of identifying them, particularly in village communities, is by virtue of their occupations. So just for clarity and just for safety, 25 2b employs the words classes and sections of Hindus And in my mind and my submission, my lords, it is only referable to Article 17 communities and nobody else.
Yes, sections
caste.
can also refer to tribals who follow Hindu religion. Sections
Yes,
where they are prevented,
it could. It could.
tribal.
Yes,
Or different religious denominations.
it could include those. It could include those.
Like a Shaivite permitted to enter a Vaishnava.
Yes,
Vaishnavite.
it would include all of that. It would include all of that without exclusion. It could include all that. But I'm saying we must draw a line of not.
It's not so restrictive only to untouchability or
So my little reservation with that, I'll explain why I have little reservation with pitching it broader, is every time, my lords, most of the submissions in this matter have come through a Hindu lens. But it's not come through a Christian or a Muslim lens to test it, because all we're doing right now is testing it. Now, if we were to say, as Justice Bagchi suggested, that a Vaishnavite can't be excluded from a Shaivite temple, in my view, with reference to 26, if the Vaishnavite or Shaivite claim denomination rights, that is available to them. I say that can be done. That's my argument. I believe there is.
Societies, huh?
No,
The entire society.
I'm just allow me to complete. I have to look.
A civil war.
I have to look at integrity in my argument. That's all I'm saying. Now, the fact is, on the ground, people don't do it. But if your lordships are asking me,
If you are
Yes.
propounding that 26, under Article 26, it should be held as a separate denomination.
yes.
Then there will be a fight between two denominations.
But that's been happening in this country for 2000 years. Malad. I'm not starting it.
They will be the catalytic agent for that.
No, not at all.
It should not be.
No. So allow me to just explain, because I know.
We understand. It cannot be required at all.
Yes.
Because, otherwise it will come under social reforms and then other.
So it may come under social reform.
But you are right
All
to
I'm saying
accept
is,
that it was meant
all
for,
I'm- no, no. All I'm saying is, no, my lords.
Mr. Gopal,
Yes,
you may argue definitely.
yes,
But please also examine paragraph 12 of Sheshmal.
yes,
It was read in the morning by
Yes.
Mr. Giri, and there is this line
yes,
that although the Acharakas have to conform to the denominational faith,
yes,
entry of another denomination
yes.
cannot be said to be a part of matters of religion.
Perhaps, but my argument, which requires only for your lordship. Yes,
That light, we have to see the words classes and sections.
yes. No problem with that.
These like
Yes,
branches of a singular tree.
yes.
And you cannot say the branch of one of the tree will not overlap another.
So let me just explain what is troubling me equally, is that if a Shia mosque says that this,
It is different, sir. You
no,
cannot
I can give you
use
100 examples.
sections
A
of
Jacobite
Hindus.
church.
No, sir.
I'm saying in any one of them.
Your argument is actually militating against yourself. When you see
Yes,
25, 26,
yes,
we should see it from a secular lens.
yes,
We cannot see it from a Hindu lens or an Islamic
That's
lens.
what I
or a
said.
Christian
Yes,
lens.
yes,
The words of 25(2)(b)
yes,
saying sections and classes of Hindus have been consciously used, that the word sections and classes will be relatable only to Hindus.
yes,
It cannot be used as sections of Muslims,
yes,
because sections of Muslims may have a clear, distinct, non-overlap character. But the Hindu sections,
Yes.
the denomination, because
Yes.
of the nature, inclusive nature of the faith,
yes.
has overlap.
No,
That is what the constitution is.
Malad,
seeking to
that
enable.
postulation would then mean that the aim of the constitution makers in introducing 25(2)(b) is to somehow protect a Hindu society in this country while not particularly giving that attention to other communities. I don't think that was the aim at all.
That is, Mr. Solicitor indicated.
Yes.
There it will be social reform.
The problem is,
legislation
correct,
To
correct.
make proactive,
Yes.
progressive interventions,
Yes,
legislation
yes,
come under the first clause,
yes,
social reforms.
yes.
But not under the second
So
clause
let-
of
let-
opening doors of
let-
all sections.
let-
There the section is
My-
relatable only to Hindu.
For a minute, if your lordships will see 27 for a minute, Article 27. 16(6) has been read to you. Just see 27 for a minute. 25, 26, 27, and 28, all four articles are under this chapter of right to freedom of religion. So 27 says, No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Right? The reason why I read this is the Constitution recognizes in 27, in 16.5, and in 25.26 that religion and religious denomination are two different things. Now, if they are two different things, the question we have to reconcile, I know we are talking about entry a lot, but the question we have to reconcile is this. Does the religious denomination, which has been given a right under 26, does it have a greater or different right from a religion whose component individuals have the right under 25? That's the question I put to myself. The answer that I find is that it does. It unequivocally does. Because you're using these two phrases differently, you have to define the denomination somehow. We have large communities across the world who are non-denominational as well, who don't therefore, like I personally don't proclaim myself to belong to any denomination of Hinduism. I don't. I'm a Hindu, but I don't belong to a denomination of Hinduism. 56% of the US are non-denominational Christians, non-denominational. They don't belong to any one of these various denominations. Now, in which case, when we define denomination, and I'm fine with the definition that your lordships may note in Mittal, both majority and minority, look at the three tests. Norm itself means that name has to be one part of it. But I think in addition, I'm coming to this point because your lordships want me to wrap up.
You understood that part. You can-
No, because definition of denomination is at the heart of this case. If a denomination has a name, it has a particular type of faith or tradition, and it has an organization, these are the three parameters for the test, it is a religious denomination. I would add a fourth respectfully, because your lordships have to formulate this. At some point, you're grappling with what a religious denomination is. The fourth is that it can include syncretic or multi-belief systems. If I, a Hindu, and my friend, a Muslim, and a third person, a Christian, decide together that we are going to form a new form of religion, where we are believing in A or B or C, and we're consecrating, we're following a faith, and we're naming ourselves. Before the Sabrimala bench, I had specifically argued this point. I had said the Ayyappas, as they're called, the believers themselves are called the Ayyappas during that 40-day period, and they follow all these various sacrifices, etc. Now, those Ayyappas come from Hindus and Muslims and Christians. So technically, whether this temple entry law will apply to Sabrimala is itself a moot question, because that is only dealing with Hindu temples. But leave that aside. I'm saying the fact that you have multiple faith people coming and believing in this, much like in the Aurobindo question, the question arises that can you define them as a denomination? Or would you say, as my ladyship had just mentioned, I think 3 days ago, that it has to be a subset of a religion, which means I, as a Hindu, can only be a member of a Hindu religious denomination, and I couldn't become a part of some new denomination which may have an overlap with Hinduism, it may not. I'm saying these are questions, Manoj. I don't have the answers to everything. I'm saying these are questions which need to be looked at. Now, coming, yes.
Freedom is always there under Article 25(1).
No, but for the denomination. I'm only on the denomination. I'm on 26. I'm saying for me, see, my right as an individual, whether I belong to the great religions or
It does not even speak about denomination at all. We are trying
I
to
agree.
put something. It merely speaks about Hindu religious institutions
correct.
of public character.
Yes, Manoj.
Anything which come within that definition only. They are
Yes.
not bother about denomination. It may be
So the pro-
denomination, may not be a denomination.
That may be,
See,
but all I'm saying
only,
is,
only two factors are required.
yes.
Consciously, they did not make a mention about the denomination. It
Yes.
only say public, it should be a Hindu religious institution, it should be a public character.
Correct. Now, when your lordship says
And
Hindu,
you are right, it should be applicable to all classes of Hindus.
correct. Now, if there is a denomination which emerges from Hinduism, which has a public temple, the denomination claims I have a 26 right. The other side claims, as your lordships are saying, the other side claims, look, it's a Hindu religious place of worship of a public nature. Therefore, I have a right of entry. That's what they say. My argument is, and I believe that there is some integrity to this argument, which is why I'm posing it. It's not like this is the first argument that came to me. I had to discard 20 before I came to this one. My argument is much like, and please note this, in Articles 29 and 30 of the Constitution, where you deal with minority educational institutions, that's why I showed you 15 and 16. Educational institutions which are run by non-minorities, which are run by religious and linguistic majorities, they have to have reservation. They also have to give 25% EWS for, as under Article 21A. But the minority educational institutions don't need to do that. Minority educational institutions, whether religious or linguistic, have the additional protection and additional right to take as many students as they want, provided, as said in Ahmedabad St. Xavier's, you have a sprinkling of non-minorities to give it balance. Right, Manoj? What I'm saying is the minority educational institution is on par with the religious denomination as against the non-minority educational institution compared to the religion. I hope I'm making myself clear. I'm saying there's a constitutional parallel to why I can,
You are
which is,
parity with 26.
yes, which is why I'm saying 25, 26, 29, 30 give you a constitutional parallel to which my argument then is not that abhorrent. When I say, as a religious denomination, I am entitled, and please don't look at it with this idea of keeping society together. That's really not our task, Manoj. Our task is to test the constitutional principle. What I am saying is, if a religious denomination identified as such, the Aurobindos, for example, they are not identified, but if your lordships were to, they get together and say, sorry, if you don't ascribe to A, B, C, D, I'm not going to allow you entry. I don't see a problem with that. And I think that arises from 26. The exclusion of the untouchables, no, there's no question of doing that. There's no question of employing child labor and saying I'm administering affairs. No, there's no question of any of that because that's abhorred by the Constitution. But I'm saying the religious denomination in managing its affairs, in doing everything that 26 affords it, is on a slightly higher pedestal, and necessarily so because the subject to other parts is not there specifically in 26. The reason why I...
So it's difficult for us to accept it, but we take note of that.
Yes, please consider that there is a constitutional parallel because any other acceptance may do violence to the express words that are at the very top. I'll just take a couple of minutes more. If your lordships comes to the second page of this, what I've handed up, the relevant concept, the back of what your lordship told.
Yeah, the 20.
Manoj, Justice Sundaresh has misplaced it.
Yeah, it's here. Yeah.
Before you go to that,
Yes.
before you go to this,
Yes,
Article 25(2)(b,
yes, Manoj.
it refers to all classes and sections of Hindus.
Yes.
It doesn't mean a particular gender.
It shouldn't. I agree. It shouldn't.
Yes.
There's no question.
All classes means all men and women.
Correct. Included in that.
Yes.
That may be. That may be. The
Therefore,
only
it
problem is,
doesn't mean women as a section.
yes. No, the only problem is, Manoj,
Women as a class.
I'm a little at odds with Justice Bagchi's formulation, but finally he's the one who will decide and I won't, about the question whether this will include a denomination in the class or section. I feel when denomination is separately spliced out and put as Article 26, would it be fair to include it here as a class or section? I feel that that may not follow. Now, also please note 26.
All that we are saying is, my brother, it does not exclude you, that's all. We will not go into the issue of it includes you or not.
Yeah.
So long as you are a public, the institution, they are in something more for us to do.
No, Manoj, I believe when you're not testing it with reference to other faiths, when
Very
the
well, very
Jacobite
well.
chapel
We
decides to exclude
got
the
it.
Episcopalian,
Yes, all right.
that is not protected
Yeah,
here.
sure.
That's why. Now, the relevant concept from part 3, Manoj, this is only to assist your lordships.
No problem.
Like I said,
No problem.
I think if there is so much history behind this and there is so much
No.
cultural background behind this, the relevant concepts which I've said from part 3, the expressions religion which are used elsewhere in the part, I've mentioned 27 and 30, religious denomination in 16, 5 and 27, horizontal rights which I've already referred to, and I've referred to, there's 11 judges decision in R.C. Cooper. Para 52 I've just mentioned, because in that para 52 of Justice Shah's judgment, this was unanimous. Huh? 10:1. 10:1, I have it here. In dealing, I'm just reading that one paragraph because it's 11 judges decision, I should. 10:1, this is majority. Article 52, para 52. It's there, the page number is given. In dealing with the argument that Article 31.2 is a complete code, etc., I'll come to the specific part. In some cases, it is an express declaration of a guaranteed right, 29, 30, 26, 25, and 32. In others, to ensure protection of individual rights, they take specific forms of restrictions on state action, legislative or executive, 14, 15, 16, 20, 21, etc. In some others, it takes the form, this is to answer my Lord Justice Bagchi's formulation regarding 19. In some others, it takes the form of a positive declaration and simultaneously enunciates the restriction thereon, 19.1 and 19.2 to 6. In some cases, it arises as an implication from the delimitation of the authority of the state, that is 31.1 and 2. In still others, this sentence, it takes the form of a general prohibition against the state as well as others, which are 17, 23, and 24. The enunciation of rights, either express or by implication, does not follow a uniform pattern. And now, my lords, apart from that, I'm coming back to this one pager. Morality, I've already dealt with. The phrase nothing in this article, I've shown everywhere in part 3 that it's utilized. It's utilized in about 50 other places in the Constitution. The phrase establish and administer, both words which come in 26, also come in 30. Which is why at first blush, while the argument may not seem attractive, I hope your lordship will consider it, because there is a different footing as far as minorities and as I believe religious denominations. So the piquant questions that I believe need answering are these. What is the effect of the absence of the reference to part 3 in Article 26? Can classes and sections of non-Hindus be excluded from their respective places of worship? Can scheduled castes be excluded from Hindu religious institutions of a private character because this uses only the word public? How can 25.2 be made to apply to 26 when it does not say it is subject to it? Are denominations only subsets of religions? If not, how do we distinguish? If you can see the diagram at the bottom, I've given the illustrations there to see, I believe there are 3 possible options in how this religious denomination dichotomy plays against each other. Option 1, if you see that Venn diagram, is where it is a subset. This is the way Justice Nagaratna had formulated it. Option 2 is where you'll see A, B, C, and D, my lords. I'm sorry. Ask them to put it on the screen, yeah, where they are. Screen. One page note. Right? Don't have it. I don't know, I was too late. So the second option, the second diagram shows religion as the large one, and then A, B, C, and D. A is where it's completely a subset, perhaps like a Vaishnavite coming from Hinduism. B is where there may be some overlap with an existing faith, but they have some other practices, like say perhaps an Anand Margi. C is where it's completely outside of faith. Aurobindo, for example, would be an example of that. C and D, which are completely outside. The third option is where they're completely distinct, where you say religious denominations cannot arise from existing religions. I think it's too far-fetched to put it, but I've given you all 3 to give your lordships an idea of how I believe these interplays exist. And therefore, last 4 questions, 6, 7, 8, and 9. What is the true meaning and scope of morality used in 25 and 26? My view is, please don't throw overboard the phrase constitutional morality. I believe that morality can only be what is determined not by parliament or a legislature, but what the court determines is constitutionally correct and valid. It can't be a majoritarian determination. It cannot be. If it is not, it has to be a determination in terms of the Constitution, in terms of 17, 23, 24, etc. So to that limited extent, I'm not saying all provisions of part 3. It cannot be. It makes nonsense of the words subject to other provisions of this part. The question 7 I've already addressed. 8, are religions or denominations treated as state for the purpose of part 3? Because that question of whether the denomination can take action against you, the right that you will agitate, you will not agitate an Article 32 right. You will not exercising 25.1 if the denomination excommunicate you. You can't file a writ in a court. You can file a suit. There's no problem. Section 92 CPC, all that, if there is mismanagement, maladministration, that is available to you. Question here is fundamental rights. Can you or a 226 be relegated to a suit and that's your only option. Is there a pressing need for the essential practices test? My answer is no. It's not. It's very clear on its own terms. And partly, like Justice Amanullah said in the morning, in many cases, it will come down to the facts of the case. There may be a very unique practice. So rather than putting down broad-based labels, putting down an essential practices test, the phrase is very clear, both in 25 and in 26 too, about managing affairs in relation to matters of religion. If there is a connection to the religion, defer to what the denomination is saying. It is critical to us. I don't think a non-ecclesiastical court should be testing that aspect of it. It should defer to what the denomination says it is. If your lordship is satisfied, it's a denomination. And therefore, the central question, in my view, is
Don't
can
have that test at all then.
Lords,
Don't have that test
don't
at
have
all.
essential practices test. No question about it. Don't have it. It's not necessary. The constitution is very clear on its own terms. I'm very grateful. Your lordship, I'm very grateful. Yeah, yeah.
1 minute, Manoj, since Mr. Shankar Narayan attributed something to my arguments. My lord, it is, I'm making it clear
18, 19, and 35.
May I then address your lordships after my learned friend finishes?
Yes, immediate after that.
Sir.
Gopal.
May we get a chance tomorrow?
Because both Mr. Rodriguez and I are also going to.
I appear for an association which runs the Dawoodi Bohra's Jamaat in Mumbai.
In my case, I am one of the original writ petitioners, and
Given a choice, we will,
I am the then president of the VHP who filed this.
see,
So they have a.
Mr. Sundaram,
Subject matter.
given a choice, we will request Mr. Gopal to hear all of you and then argue. But we will leave it, to you, why don't you?
We are at your lordship.
But I'm more than happy to do so.
Gopal, do it after.
We just wanted to tell.
And 35. These are the review petitions in which I appear.
19,
901.2, 18, 19, and 35. Let me just set out who the parties are.
Now, the written arguments, what is the volume and what's the page for you?
Mine is at volume 1.2, page 242 is where my written submission starts.
1.2,
1.2, page 242.
page 246.
242, printed in red. And PDF, I think it's also 242.
1.2.
Please, it's volume 1.2, PDF 242, and it's also printed in red 242. My lords has it?
242. That's right.
Please, minutes.
Ah.
So these are the review petition numbers. Kindly make a note of the parties from my lords.
Yours is on behalf of Pandalam.
The Pandalam family, which is the foster family of the deity itself. So which is why I'll have something to say on the issue.
Yes.
I'm also representing Chetna, which is a women's organization that stands in support of the temple's tradition. I also represent an All India organization of Ayyappa temples, which is writ petition 39642. I'm also representing the Shirur Mutt in this matter, which is IN number 18313 of 2020. I also represent the Tantri of the Padmanabha Swami temple, who has a direct say with respect to the practice of the Sabarimala temple, and that is 18326, and the Chilkur Balaji temple 11778 of 2020.
That you have mentioned almost in para one of your opening.
I have. The other three IAs I have not mentioned with respect to Shirur Mutt, therefore I'm pointing this out. Fair disclosure, these three IAs for intervention were dismissed by the previous bench on 10th of February 2020, but my submissions will be common. Millards, I will primarily focus on the relationship between 25 and 26, that vexed question. I'd only request my lords to kindly come to page number 251, para 6 of my written submission, in terms of the questions that I wish to canvass.
251?
251 printed, para number 6.
Yes.
My lords has it, my lady has it, please. My lord Justice Bakshi has it, please. It is humbly submitted that in order to address the above questions, which is the questions framed for reference, and additional questions, a holistic understanding of part 3 is called for, of which articles 25 and 26 form part. Since part 3 of the Constitution deals with fundamental rights, the following foundational questions must be asked. I'd only request my lords to kindly take a look at the questions. Who do these rights inhere in? Who are they available against or in relation to? What is the nature of rights? What are their limits, and who enforces these rights? One question that my lady had actually asked, which I think is central to the question of relationship between 25 and 26. If 26 is about denomination, under which provision do non-denominational institutions trace their rights? That was the central question that is asked. In my humble view, all of this turns on the history of Articles 25 and 26. And what I've done for my lord's consumption is, my lords would find this spiral folder on everybody's bench. If my lords could kindly take a look at this. This contains the history of 25 and 26 in its entirety. And that will also explain the relationship between 25.2 and 25.1. I'd only request my lords to kindly take a look at this document, because this, in my humble submission, will be the nub of the matter, the core issue here. Because that seems to be the question that has been repetitively coming from the bench. So I request my lords to kindly mark paragraphs 1 until 30, rather 32. That is, the first 22 pages of this note are only extracts of the entire history of Articles 25 and 26, including the transition of the language as to how it emerged. I request my lords to kindly bear with me as I walk my lords through this history, because this should answer more or less most of the questions put in relation to the following questions. What is the relationship between 25.2 and 26? Question number 1. What is the meaning of a denominational institution? And is religious denomination different from a religious institution? What is the distinction? I want to show all of that. My lords may kindly have page number 2 of this spiral folder. I'll only focus on this and nothing else for now. My Lord Justice Amanullah has this, please. So, my lords, just kindly give me some leeway to walk my lords through this, because this should answer everything. Prior to the adoption of the Objectives Resolution on 22nd of January 1947, there were 2 preliminary notes on fundamental rights which shed light on the predecessors to Articles 25 and 26. One is Mr. B.N. Rao's note, who was the constitutional advisor, who broadly enumerates the kind of fundamental rights. Kindly see the first prototype of Article 25 under Mr. K.T. Shah's note, which is extracted in para 3. My lord sees that. So in the draft clauses presented by Mr. K.T. Shah in his preliminary note of 23rd of December 1946, clause 15 reads as under: every person living in the Union of India and is hereby guaranteed the right to freedom of conscience, which includes freedom of belief, worship, or profession of any religion, faith, or doctrine, as well as the negation of such belief, subject to public morality and order, subject to such laws as ensure the maintenance of public peace, tranquility, and good relations amongst the various sects and communities in the country. After the adoption of the Objectives Resolution, my lords, 5 subcommittees are appointed which deal with fundamental rights. Now kindly come to the next page, which shows who are the committee members with respect to the Fundamental Rights Committee. That is on the next page. I would request my lords to kindly read para 5, because this will show that 25.2 as it exists was always meant to be a proviso to 25.1. That is, it was never intended to affect 26 whatsoever, is an argument that was being made through interpretational route. I'm showing that historically this has been the case, which is, I'm leaving the consequences for my lords to judge. I'm only saying history of these provisions shows that 25.2 was meant as a limitation only on 25.1, because which is why it speaks of nothing in this article, and there's a reason for it. Kindly come to para number 5 at page number 3. All citizens are equally entitled to freedom of conscience and to the right freely to profess and practice religion in a manner compatible with public order, morality, or health. Please see what it says next. Provided that the economic, financial, or political activities associated with religious worship shall not be deemed to be included in the right to profess or practice religion. Therefore, it was meant to be a proviso. Kindly note, in my humble submission, the better part of these provisions and their amendments came from Kulapati K.M. Munshi, who can rightly take credit for crafting the language the way it is. So this is the proviso. Now, I request my lords to kindly take a look at the proviso for a moment. In the second line of the proviso, it says religious worship. My lord sees that. That subsequently becomes religious practice, because they decided that worship was too narrow and this should cover practice as well. And that was the discussion this was not even in the Constituent Assembly. This was in the committees before it went to the Assembly. Now, my lords may come to the next page. Para number 6 is Mr. Harnam Singh's draft. And my lords would see clauses 5 and 7 are the clauses introduced by him, which are more or less similar to the original draft. Now, I would request my lords to kindly come to para 7 at page number 4. And I'd request my lords to kindly make a note of these points for one good reason. Courts have been grappling since 1954 on the question of how do we interpret denomination. And Shirur has given the impression that denomination is something exalted, which is distinct and unique. Dr. Ambedkar and K.M. Munshi were not of this view, because 26 was meant to be a specific application of 19(1)(c) in a religious context, which is freedom of association is provided in 19(1)(c), and the limitations on freedom of association are in 19(4). 26 was meant to be a freedom to religiously associate. So in that sense, 26 is a specific manifestation of 19(1)(c) in a religious context. And therefore, denomination was never used in the context of giving it a separate character altogether. And I'll show my lords this. Please, I'm so sorry. My lords had a question.
No.
Please, minutes. And this will emanate from the clauses proposed by Dr. Ambedkar on 24th of March 1947, page 4, para 7. What I'm trying to do through this endeavor is to show we need not go down the path of interpretation and get caught in the question of what is a denomination, when those questions have already been answered by the history of the provision. I've gone through all the written submissions. In my humble view, this portion or this history was not there, and therefore I thought this could put the matter to bed. Now, kindly see this. My lords would see 14, 15 onwards. Can I just read this for the court's benefit? These are the proposals under Dr. Ambedkar's note of 24th of March 1947. Under the heading Fundamental Rights of Citizens, I've given the relevant page numbers from the existing compilation of the court. The state shall guarantee to every Indian citizen liberty of conscience and the free exercise of his religion, including the right to profess, to preach, and to convert within limits compatible with public order and morality. This is more or less Article 25. Now, kindly see 18 onwards. Clause 18, 19, and 20 shed abundant light on the predecessor to Article 26. Persons following a religion shall be guaranteed freedom of association and shall have, if they so desire, the right to call upon the state to pass legislation in terms approved by them, making them into a body corporate. Can I request my lords to turn the leaf and kindly see clauses 19 and 20? every religious association shall be free to regulate and administer its affairs within the limits of the laws applicable to all. Religious associations shall be entitled to levy on their members, contributions on their members. This is not relevant. 18 and 19 show that denomination was preceded by religious association, which is why in the debates, my lords would not find a specific discussion on what would amount to a denomination. Because a denomination is always meant to be understood as a collective expression of individual rights. Therefore, every body of people which comes together under a common belief to establish an institution will be entitled to rights under Article 26. So here's one question for my lords to consider. If 26 had not been there, what would have happened? It would have been still part of 25(1), except that they decided to pull it out of 25(1) and give it a separate character for one good reason. Because part 3 can be applied to 25, but part 3 cannot be applied to 26. And that is conspicuous in the absence of the language itself. Therefore, to ensure that collective rights or denominational rights or associational rights are not fettered by the limitations of 25(1), the bundle of rights within 25(1) were plugged out and carved out as Article 26. And there is a discussion to this effect. Therefore, the submission before my lords is, there is a very conscious reason for keeping 26 as a separate right as opposed to 25(1). There is a conscious reason for making rights under 25(1) subject to part 3, but not 26. And the word denomination does not have a definition in the Constitution because it was always meant to be understood as a collective or an association. Now, my lords may kindly come to the paragraph under the indented paragraph at page number 5, just about para 8, which is my statement. I request my lords to kindly make a note of this. Draft clauses 18 to 20 of Dr. Ambedkar's draft contain the germ of Article 26, which indicates that denomination has been referred to as religious association and has not been subjected to any higher standard as required by Shirur Math. Then my lords may come to para number 8. Again, K.M. Munshi on 26th of March 1947 puts forth before the subcommittee of fundamental rights Article 6. I request my lords to make a note of Article Roman 6 because it is this Article Roman 6 that becomes Article 1314 at some point, Article 1920 at some point, Article 2021 some point, and then becomes 2526. That is the journey of this entire thing. Now kindly take a look at the language here. This will show that 25(2) is only subject to 25(1) once more. Rather, it applies only to 25(1). All persons are equally entitled to freedom of conscience and the right freely to profess and practice religion in a manner compatible with public order, morality, or health. The right to profess and practice religion shall not include economic, financial, or political activities associated with religious worship. My lord sees that. Then, so what was given as a proviso is then fused into a composite provision. Then my lords may come to the next page. At para number 9 on page number 6, is the revised version of Article 26 introduced as part of Sri B.N. Rao's draft. Please see what it says. Every religious denomination shall have the right to manage its own affairs in matters of religion and to own, acquire, and administer property, immovable and movable, and to establish and maintain institutions for religious or charitable purposes consistently with the rights guaranteed in this Constitution. This becomes later in accordance with law under 26D. Now, my lords would see what is missing here is, my lords would see that public order and morality is completely missing here in this particular draft. That gets introduced later. So I'll show that. Now, my lords may come to para number 10 at page number 6. This is the combined draft of Article 6, which is the future Articles 25 and 26, as adopted on the 26th of March 1947. My lords would see that clause 1 of Article 6 is proto-Article 25, or the predecessor to Article 25, rather 25(1). Then my lords would see that the explanation with respect to Kirpans has already come. And please see, 25(2) was then inserted as an explanation to clause 1. Therefore, it was always meant to be limited in its application. I'm just reiterating that point over and over again, that it never severs the umbilical cord that connects 25 and 25(2) throughout its entire history. It becomes an explanation, it becomes a proviso, then it becomes 25(2). That's the only difference. Then kindly see this. This is the new clause that Shri B.N. Rao recommends at the bottom of Article 26. My lords could see, kindly see the bottom of page number 6. Every religious denomination shall have the right to manage its own affairs in matters of religion, so on and so forth. My lords has already seen that. Now I request my lords to come to the next page.
There it says consistently with the rights guaranteed in this
Constitution. And then my lady would see how that language gradually changes.
That is because it becomes diluted.
I'm so grateful. It becomes diluted, and not just that. Wherever it refers to clause 6, that is clause 1 of Article 6, which is 25(1), initially it kept saying subject to the rights in this chapter. That chapter becomes part later because everything is reworded. So chapter becomes part, and I'll show all of those changes as well. Kindly come to the next page, para number 11 at page number 7. My lord sees that?
Yes.
My lord, Justice Madhavan has it?
Yes.
Please.
One more.
I'm so grateful. On 27th of March 1947, the following portions were added to clause 6. Now begins the Irish influence. So 44 to degree 1 and 44 to degree 5. Degree 1 speaks of 25(1), degree 5 is 26. So denominational rights come from Article 44, clause 2, degree 5 of the Irish Constitution as it existed then. Article 44, subclause 2 and degree 1 was the equivalent of 25(1). Now kindly take a look at this. My lady may come to, in fact, my lady can, my lords can perhaps ignore para 11. Kindly come to para 12 on the next page. On 29th of March 1947, this is proposed. The provision relating to freedom of conscience and the right freely to profess and practice religion was amended so as to include at the end of the words and with other rights guaranteed by this constitution, which becomes a reference to subject to part 3. Then kindly see para 13. On 30th of March 1947, the following explanation was sought to be added. To clause relating to freedom of conscience, add the following explanation. This is explanation 3. No person shall refuse the performance of civil obligations or duties on the ground. Gradually, this explanation is done away with at a later point of time. My lady may then come to para number 14 at the bottom of page number 8. 3rd of April 1947 is an important milestone because on that date, the draft report of the subcommittee of the fundamental rights is shared with the advisory committee. Please see what are clauses 16 and 17 there. 16 says, all persons are equally entitled to freedom of conscience and right freely to profess and practice religion, subject to public order, morality, and health, and to other provisions of this chapter. This chapter becomes part later. Kindly come to the next page. And once again, my lady would see 25(2) is an explanation 2 to Article 16, draft Article 16. The right to profess and practice shall not include any economic, so on and so forth. My lords is aware of this. 17 is 26. Then my lords could come to para number 15, where we basically see that Alladi Krishnaswamy Iyer, as part of his notes on this draft, cites the Jehovah Witness judgment. No wonder it features later in subsequent judgments, specifically saying, how do we deal with this particular situation? Because what was the facts? Can I just take 30 seconds to explain what happened in Jehovah's Witness case in my own words? With my lord's permission, may I, minutes? So in the Jehovah Witness case, the witnesses, or rather the practitioners of that particular denomination, also took an anti-national oath, specifically saying that they will not swear allegiance to the empire of Satan. That was a specific position. Then they also had properties where they would undertake their own discussions to, let's say, give effect to their belief. The government took over that entire building. The court finally said, you can kill the effect, but you can't kill the practice of the belief, which means you can take the property, but you don't get to say that they can't believe in this. That was the position ultimately that emerged in it. Kindly take a look at para number 16 at page number 10. Now, there are 3 ladies who have played a formative role in the formation of fundamental rights across the board. Hansa Mehta, Rajkumari Amrit Kaur, and of course, you have Mr. M.R. Masani. Can I request my lords to kindly take a look at the top of page number 10 just for a moment? Please see this. Durgabai Deshmukh. We'll come to that. The right to profess, I'm so sorry, sir, thank you. The right to profess and practice religion shall not preclude the legislature from enacting laws for the social betterment of people. This is the prototype of 25(2)(b), which again shows, so we can't argue that 25(2)(a) applies to 25(1), but 25(2)(b) applies to everything. That may be a bit of a problem to argue, because if nothing in this article is the preamble to 25(2), that means both portions of 25(2)(a) and (b) apply or don't apply only to 25(1), not to 26. That is the history of this particular provision. Then my lords may come to clauses 16 and 17. Please see, this is on 14th of April, 1947. Just above para 17, my lords would see, clause 17 was accepted as is where is. Kindly see what happens to clause 16 again. Same thing. 25(2) retains its position as an explanation to Article 16, which is 25(1). Then kindly come to the next page. I'll request my lords to kindly come to para number 18 for a moment at the bottom of page number 11. Oh, 18 is not necessary. We'll just go to para 19. I'm so sorry. My lords may come to para number 19, and this will help my lords also assess the meaning of classes and sections. My lords, Mr. Manuel has it. Page number 12, at the bottom of it is para number 19.
Yes.
Please see this. Notwithstanding any custom or usage or prescription, all Hindus without any distinction of caste or denomination shall have the right of access to and worship in all public Hindu temples, so on and so forth. This is the right of access. Kindly come to the next one. Rules of personal purity and conduct prescribed for admission to and worship in these religious places shall in no way discriminate against or impose any disability on any person on the ground that he belongs to impure or inferior caste or menial class. Which is, can I just elaborate on this? You can say that this is the acharam or the custom of this particular temple. But if you use birth-based restrictions to prevent access or entry, then that will certainly be in the teeth of the law, no matter what. And that is what translates to 25(2)(b). So while I'm not arguing the merits of the Sabrimala case, I'm just giving this by way of illustration that if the temple says because of the deity's Naishtika Brahmacharya character, there are certain proscriptions or prohibitions or restrictions on access to a particular class of people, which has got nothing to do with jati or caste in any way whatsoever, because that class is across castes as far as that restriction is concerned, then it doesn't run afoul of this prohibition. Therefore, I'll build this argument as I go along. Section and class are not to be treated as two different classes altogether. Class has been used consistently across the debate to refer to caste. Section has been used as a cross section within that particular class, or it can go beyond it, but it was always meant to have a caste-based connotation, not gender-based connotation, because if that happens, then religious diversity and rights under 26 can be easily defeated, because there are temples on both sides, or even institutions on both sides across the board, where prohibition applies to people across genders. So for instance, there is this Artikal Bhagavati temple in Kerala, where access to men is restricted for specific reasons. I'd also given this example in 2018 in the first round. There is a temple in this district called Satabhaya in Odisha, where the priestesses are all of them are Dalits, and there's a reason for it. Apparently, the original Brahmin priest ended up seeing the deity in its unclothed form, and therefore, to atone for it, he decided to hand over the temple to 4 Dalit priestesses, and till date, for the last 400 years, that practice continues. The only time the practice was violated or breached in the recent past, perhaps around 2018-19, was because of rising sea levels. The Shivalingam had to be lifted heavily, or rather it has to be completely bodily lifted, and therefore men were allowed for that limited purpose. So what I'm trying to say is that rights under 25(2)(b) or the enabling power under 25(2)(b) has to be applied in a narrow sense. Otherwise, the purpose of carving out 26 will be completely defeated. I am not making a policy argument. I am making only a statutory argument in terms of what is the history. I'd only request my lords to kindly come to para number 20 at page number 13 for a moment. Following with the revisions which were proposed as far as clauses 16 and 17, kindly see in explanation 2, please see that is the second indented paragraph. Religious worship was substituted with religious practice. My lords, the Honorable Chief Justice sees that. So here, kindly see this. It says, all persons are equally entitled to freedom of conscience and right freely to so on and so forth, and other provisions of this chapter. And in that explanation 2, which is 25.2, for the words religious worship, practice shall be substituted. Therefore, financial, economic, political, or any other secular activity, previously it was associated with religious worship, it becomes religious practice. Then my lords may come to para number 21 for a moment, where I basically summarize the net result of the discussion on clause 16. Can I request my lords to kindly take a look at para 21 at page number 14.
Practice is broader than religious worship.
Worship. I'm so grateful. That was the intent, because otherwise it also limits rights under 25.1. And therefore it was meant to widen up the entire conversation, both on the 25.1 and 25.2.
So, and also it enables the state to make the law.
So grateful. That
State
means
to make the law then.
I'm so grateful. That means the power of the state is not limited only to aspects of worship. It also extends to practice. I'm with my lady.
No, it doesn't extend to worship. It extends to practice.
Practice. Fair enough.
It is broad enough, but at the same time, it
Protects
does not
worship.
extend to worship should be the.
I stand corrected.
Yes.
Grateful. I'm grateful for the nuance. I didn't think of it that way. I'm grateful for it. Kindly take a look at para 21. And I request my lady to kindly see Romans 1, 2, 3, and 4 for a moment at page number 14. My Lord Justice Kumar has it, please. The term religious worship was replaced with religious practice in explanation 2. This explains the use of religious practice in 25.2a. Social reforms were made permissible with the consent of, kindly underscore the words, legislature. Which means this addresses one fundamental question across the board. Subject to clause under 25.1, enabling power under 25.2, subject to clause under 26 are powers to be exercised only by the legislature. Is the humble submission that all of that, which is why I think Mr. Gopal Shankaran said it is vertical in that sense, that the restrictions on those rights can be applied only by the state. And the state, my lady is aware, under Article 12 and 13, state does not include the judiciary in its judicial capacity. Mirajkar and several judgments have held to that effect. Therefore, for the purposes of this chapter or this part, the reference to state is to the executive and the legislature. And in my humble submission, it does not include the judiciary. Therefore, the question of entertaining any writ petitions, challenging those practices on the ground that it violates any of those subject to provisions, does not even arise, simply because those powers are limited to the state. And this perhaps could answer the question differently. I'm so sorry, my lady had something to say.
No, if the state, it enables the state to make laws.
Yes.
To bring in social reform.
Correct,
Such
correct.
as, for example, entry.
Correct.
Now, the question here is not, the controversy is not that the state has banned entry as
Right.
such.
I understand.
State has made the law,
So
rule,
grateful.
act and the rule
Right.
for entry.
I'm so grateful.
Under that, because of the custom, there is a prohibition
So can I,
in the Kerala Act and rule.
my lady is correct. So here what I have done,
Made a law banning entry.
please,
State has made a law promoting entry.
I'm so grateful.
But under the custom,
Yes.
there is under the 3B rule,
Yes.
there it is an exception.
So may I just respond to this? There are two specific portions of my written submission, both the old and the new, where I've specifically addressed this. And can I volunteer to respond to this before I continue with this? Because a question has arisen from the bench. Codification of a pre-existing religious practice by the state does not make that practice amenable to judicial review, because it is not exercise of rights under 25.1 or 25.2 where limitations are imposed. The submission is, if judiciary cannot or the courts cannot preside over constitutional challenges to practices themselves per se, merely because the state rolls that practice by way of a legislation, that doesn't make it amenable to review, is my humble submission. Because at the core of it, my lady would still be getting into the question of 25.1 and 25.2 in that sense.
In other words, whether the rationality of that custom can be questioned in a court of law.
I'm so grateful. That's the question. And if I may make this humble submission, I'm therefore applying the simple principle that what cannot be done directly can also not be done indirectly. So if you cannot get into the rationality of a religious practice, ipso facto,
This might
merely,
be-
my apologies.
Might hit the basic structure.
May I answer the question?
Yes.
I'm so good.
You can say the role of the court is very restrictive.
Restricted.
limited
I'm
restrictive.
grateful. I'm
That would
grateful.
be a better argument.
I'm with my lords on the
That's
point, which is in the process of entertaining those writ petitions to the challenge, again, ERP test cannot be applied, whichever way that route is, which is the rewriting of the rules of religion would be beyond the scope of judicial review under Article 32 and 226 is my humble submission. Since the question of rationality was raised, I think Justice Varali had.
Slightly different, but
My
the
apologies.
moment you expand the wing of the state or the executive,
Please,
the
Minister.
power of judicial review automatically comes.
I'm so
If
grateful.
the state in the name of social welfare,
Right.
suppose prohibits a religious practice,
Right.
who will examine?
I'm so great. Can I answer this question? When the state, I'll just show one thing. Can I request my lords to kindly come to that portion of my written submission where I've answered this question straight off? Can I finish this and come to that minutes? Just so that the flow is not broken.
The power of judicial review, there is no need to attack on that power so
I'm
much.
with my lords. Fair enough.
That is, we understand that limitations are there.
Please, minutes.
But to say that there is no power at all, it may also be very difficult to you.
No,
It's
Millet,
a very
I agree with my
hypothetical
lord's point.
situation.
I
It will
completely agree.
again depend upon
Please.
the situation and
Can I perhaps request my lords to come to page number 27? I'll show this at a later stage where I've addressed this question. Allow me to just complete this
no.
train of thought.
Go ahead.
Please take a look at this.
yes.
My lords, I'll take some time. My lords may kindly come to para number 21. So social reforms were made permissible. The Kirpan explanation or the exception continues. Explanation 3 was omitted, which was civil obligation on certain religious institutions. Then kindly come to para number 22. In my humble submission, this extract from Shri K.M. Munshi is necessary to understand the purpose of 26. Kindly see this, and I think Dr. Dhawan actually pointed this out. Does the honorable bench have this? Kindly see para number 22. Religious freedom is meaningless if this clause is deleted, which is on clause 17, the equivalent of 26. Fundamental freedom of religion necessarily carries with it the right for a religious denomination to retain property, which means when denomination was used here, it was not in the sectarian sense, but to say any collection of people exercising their rights under 25(1) would have and would need the right under 26 to give manifestation to that right in an institutional form, to run institutions. Because at the end of the day, that belief also translates to charitable intents, educational intents, religious intents, so on and so forth. Then kindly see, this clause was not objected to by Dr. Ambedkar. He only rephrased it in a slightly different way, which is at the bottom of page number 14. No religious denomination shall be disqualified to manage its own affairs. That would cover the case. That was Dr. Ambedkar's suggestion. Then kindly come to the next page. So Article 17 or 26 was reworded in this fashion, which is extracted on the top of page 15. My lord sees that. This was the entire paragraph. And therefore, my lords, I made the point here that clearly the word religious denomination, there's a typo, it's not word, it's the word, was not meant to be used in a restrictive sense, since it was meant to give effect to religious freedom, which was available to everyone. Consequently, the term religious denomination has been used as a synonym for religious association. There are multiple typos here. My apologies for it. This was dictated last evening. Kindly come to para number 23. And my lords would see that on 22nd of April, 1947, these were the revised versions. Again, explanation 2 continues with clause 16. Then my lords may come to the next page, page number 16. Page 16 speaks of clause 17. And then my lords may come to para number 24. This is the interim report of the Advisory Committee on Fundamental Rights of 23rd of April, 1947 under the chapter Justiciable Fundamental Rights. So clauses 16 and 17 become the new 13, 14. They change numbers multiple times, but the spirit remains the same as my humble submission. My lords may then come to para number 25 on the next page. This addresses the second portion of 25(2)(b). That's what I'm coming. At page number 17, para 25. My lord, Justice Masi has it. Please. The interim report of the advisory committee was presented to the Constituent Assembly on 29th of April 1947 by Sri Sardar Vallabhai Patel as the chairman of the committee. When clause 13 was taken up for discussion on 1st of May 1947, again it's Sri K.M. Munshi who proposed to add the words, and for throwing open Hindu religious institutions of a public character, kindly mark the words to any class, it should have been or section of Hindus. Class or section of Hindus. This was meant to be added to explanation 3. So kindly see explanation 3 on the top of the page, where it says, from enacting laws for the purpose of social welfare and reform, to that this portion was meant to be appended and said, and for throwing open. Now please note, class or section have been used as legal synonyms for a specific reason, because they were dealing with the realities of that day. And therefore it always had a caste-based connotation. Is a humble submission. Whether my lords chooses to use the word class or section wouldn't make a difference. Then kindly come to the next page. Sorry, my lords would see. So after the addition of these words, on the next page at page number 18, the new explanation 3, which is Proto 25.2b.
25.2b.
I'm so grateful. So this is it. This is 25.2b. Now, my lords, kindly see. Clause 14 was taken up. 14 was for 26. By now, it becomes 13 and 14, 25 and 26 respectively. So it basically said that all of this will be subject to general law. They just decided to drop the word general and became subject to law. And that subject to law then is appended to 26D at the end of it. It is meant to apply to 26C as well as 26D. My lords may then come to the bottom of page number 18, page number 27. Sorry, para 27. Now, kindly make a note of this. This is when these are all discussions by the drafting committee. After the drafting committee has been appointed on 29th of August 1947, extensive discussions are undertaken. These are discussions by the drafting committee. Now, this, my lords, at the bottom of page number 18 is the provision with respect to 25.1. Kindly come to the next page. No structural change whatsoever. And now my lords would see 25.2a remains as explanation 2 and 25.2b becomes clause 2 of this particular clause. This is the nature of it. This is the entire discussion. Now I request my lords to kindly come to page number 20, para 29. So sorry, kindly take a look at para 28 at page number 18. Insertions have been made with respect to public order and morality in clause 20, which is 25. And then my lords would see, now comes the familiar construction of this language. Nothing in this section shall preclude the state from making any law. A and B have been provided for. So that's 25.2a and 25.2b. On the next page, my lords would see clause number 21, which is the equivalent of 26, which has taken a position or a structure which is almost similar to Article 26 as it stands today. So for my lords, what I have done is I have annexed this entire discussion as annexures A, B, and C to this note. So can I request my lords to kindly come to the index for a moment? I won't walk my lords through the entire document. I'll just show the index. Kindly take a look at it. Annexure B, which is entry number 3 of the index, which is the discussion of 6th of December 1940.
Running page?
Yes, index of this spiral bind.
Spiral 50.
No, running page.
Running page 50. 50 to 86. Kindly make a note of this. This discussion on 6th of December 1948 was a discussion with respect to Article 19 before it became 25. So 19 to 25 as a transition is covered in this entire annexure, 50 to 86. Just so that my lords knows that I have not chosen to selectively. Then annexure C, 7th of December 1948 is on Article 26, which was previously Article 20. So page 87 to 96 covers 26, the earlier avatar being 20. 50 to 86 covers 25, the earlier avatar being 19, just before its adoption. Therefore, I'm just summarizing this conversation for my last consumption at page number 21, para 31. Kindly take a look at it. Does the bench have it? Page number 21, para 31. Please, minutes. What emerges from the above history is as follows. My Lord Justice Sundaresh has it.
Yes.
Please. Article 25(2) is a limitation only on Article 25(1) and does not extend to Article 26. In my humble submission, an argument to the contrary would be an ahistoric argument. It will be an ahistoric argument with no basis in history if an argument to the contrary is presented, because this is the history of it. Part 3 does not apply to Article 26, is the second summary. Third, religious denomination as used in Article 26 is a reference to any religious association of people held by a common belief. The exalted requirements cast by Shirurmat do not apply, and no declaration is needed to enjoy rights under Article 26, since it is seen as a manifestation and corollary of rights under Article 25. Since there is no definition for religious denomination in the Constitution, nor is there a separate identification of rights for non-denominational institutions, it means that Article 26 was meant to cover collective rights of religious associations. Kindly see the last 4 lines. Simply put, Article 26 is another form of 19(1)(c), but applied in a religious context. This is also evident from the similarity and limitations applied to 19(1)(c).
Oh, we understand your argument.
Please.
We sum it up.
Great.
25(2)(b) will be applicable to the persons,
I'm so grateful.
but on the contrary, it will not apply to the religious denomination.
Please.
Right?
Grateful. I'm so grateful. There's one additional point on that. Can I request the bench to kindly take a look at 26?
What if the persons are all members of religious denomination?
I'll just come to that. Kindly take a look at Article 26. I'm making a.
How do you give effect to it?
I'm so sorry, Mel.
How do you give effect to it? You're asking.
Can,
How do you give effect to this? If your argument is accepted,
please,
if 100% join together
please,
and create a religious denomination,
please.
if your argument, it will apply to 100 of them individually, but it will not apply to the institution.
That's why I wanted to show one nuance from Article 26. Could my lords kindly have the provision before my lords for a moment? This is a middle path.
Yes.
So this is for my lords to consider that denominational rights cannot be elevated to the status of minority rights. That's not necessary. That equation I have to disagree with. And therefore, in that sense,
So we take it in so far as the religious denomination are concerned.
please,
There is no question of application of
Shirur.
social reform or social welfare.
No, I won't make
Yes,
that.
we're asking
I'll answer.
you because you're pitching it so high because
I'll
we have to ask,
I'll
suppose you can't, state cannot go into that line at all.
In fact, my lords, can I make the submission?
Yes.
On the position that Article 17 has become part of the corpus of public morality, I'm entirely with Mr. Gopal Shankar Narayanan. That question cannot be run away from under any circumstances. The second point for my lords to consider is, kindly take a look at Article 26 just for a moment along with me. It is not as if 26 has no limitations whatsoever. It is not as if the state has no power whatsoever with respect to rights under 26. So there are two approaches. I'd only request my lords to kindly be patient with me because I'm building two arguments which will address my lord's question. One, public order, morality, and health literally are, in my humble submission, are like Akshay Patras. They are so broad and huge and wide enough that any concern that the state may have with respect to, let's say, some kind of social justice reform is capable of being accommodated within 26 without having to come through 25(2). And this is retaining the consistency of the argument, which is 26 need not be affected by 25(2). That does not, I'm sorry, not such a question.
Constitutional limitation under 25(1). 26, it limits your the right to practice, profess, and then you see, subject to public order.
I'll come to that.
To that extent, you can say public order or morality
Well,
and health.
please.
Insofar as your right to administer
I'm
and
grateful.
manage a property, to that extent it will come.
I'm grateful. So can I just request my lords to take a look at
You
this?
can't just piecemeal, you can't go into the other thing,
My
you
lords
can't
is
go to the
correct.
other thing.
My lords is 100% right on that, which is why let me not join issue with my lords on the point. Let me just explain where I'm coming from on this point. My point is 26A, B, C, and D. So a denomination has rights both under 25 and 26. It's not as if denomination does not have rights under 25 because it says person. State Trading Corporation 6-1 judgment of this Honorable Court clearly says person includes a body of people, body corporate, including companies for that matter, because a distinction has been struck between citizen and person. Second, rights under 25(1) of the denomination are different from the rights of the very same denomination under 26. So what I'm trying to submit is 25 addresses a different basket of rights. 26 addresses a different basket of rights of the very same denomination, which means, kindly take a look at A, B, C, and D. Let me just explain this argument from my perspective.
See, one way, before you do that, 26B is in matters of religion,
I'm so grateful.
but 25(2)B is with regard to social welfare and reform.
I'm grateful. That's the point.
Distinction.
Distinction
between
has
the
to be
two.
drawn. Therefore, I'm trying to make the submission
In
that
the
the,
guise of making social welfare or
you
reform,
can't affect 26B.
can't encroach upon matters of religion.
I'm so grateful. So my submission would be, kindly think of religious denomination as this branch which enjoys two sets of rights. One set of rights falls under 25(1), another set of rights falls under 26. You can certainly affect 25(1) rights because that's what 25(2) permits. But in the garb of doing so, you will not venture into the realm of 26 because there are only three permissible lenses permitted for 26: morality, order, and health.
What Dr. Singhvi also argued.
I am grateful. The difference is Dr. Singhvi's argument connects 25(2) with 26. I am saying you don't need to go down that path as far as 26 is concerned, because if you can delineate the scope of rights between 25 and 26, this neither here nor there argument, my apologies, I have to use the biblical term dog in the manger, that argument cannot be used, or that kind of an approach cannot be had where you sail in both boats. In my humble submission,
You will require judicial review then. You'll have to come to court to say my right under 26B is affected.
Please.
In the garb of making
25.
no under 25(2)B.
I am so grateful.
Then you have to come to court.
I have to come to court. Therefore,
But
I agree. State action is amenable to judicial review. I stand by that position. That's what my written submission says as much, in any way. In fact, I have some answers even to the questions that were raised by the other members of the bench. Let me just answer this question.
So, Mr. Deepak,
Please, Manoj, please.
if this interpretation is accepted,
Please.
that the affairs relating to matters of religion
Yes.
and the right to profess, practice, propagate religion
Yes.
are basically a subset, affairs of religion in the bigger set of rights.
In the universal set.
So you yield to the argument, essential religious practice is what is relatable to 26B, whereas other religious activities are more generic and is 25.
I have a slightly different approach to it. Can I request my lords to kindly indulge this argument? I could be wrong, but nevertheless, let me canvass and ventilate what I think is the position.
Because you are now diverting from 25 to A, secular activity
I get
and
it.
religious activity in complete different
I'm with my
modes. You are mirroring 26B
right.
against the bigger canvas of 25(1).
Please.
And in this situation, whenever a social reform legislation comes into being,
Please.
or whenever any exercise is undertaken to test
Right.
the matters of religion under 25B,
Right.
the court will be entitled to look into the essentiality, or as it is said, integrality, so that there is no hollowing out of that religion.
I'm so grateful.
This is one.
Please. I'm so
Secondly,
Yes,
please also consider the interesting difference after Dr. Ambedkar
Yes.
brought in the idea of association, religious association.
Please.
The word association was not used,
Correct.
but denomination was used
Yes.
in inspiration from Article 44 of the Irish Constitution.
Please.
So denomination needs to be given a more contextual interpretation than association under 19(1)(c).
Can I respond in the reverse order in the way the questions have been put? Because I think it's the easiest from my own memory. Please consider this. The comparison with Article 44 of the Irish Constitution, and I think we have actually discussed this so that this argument can be presented. The Irish Constitution recognizes the existence of God. It is not a secular constitution. It's the first submission. Second, Irish Constitution effectively treats denomination as a congregation, because every congregation is a denomination within that particular legislation. Therefore, no exalted standards are sought to be met or imposed or cast as far as Article 44 of the Irish Constitution is concerned. The surprising part is, by the time denomination it travels from Ireland to India, denomination suddenly becomes a higher right, which is not the case, because the anomaly it will create is denominational institutions are somehow great, they enjoy greater protection with respect to state compared to non-denominational institutions. That would militate Article 14, which is to say, that we can't interpret this in such a way, and that is perhaps where my disagreement comes with Mr. Shankar Narayan on that issue, that denominational institutions, if they're elevated to such a status that non-denominational institutions are practically seen as destitutes as far as constitutional rights are concerned, that's a violation of Article 14,
Sir,
if I may.
if non-denominational institutions are enjoying Article 25(1) right,
But they won't get the same protection as 26.
naturally, because
Which is why the
there is
submission-
a reasonable classification with regard to a greater commonality in denomination institution than the diffused nature of a non-denomination religious activity.
I understand where my lord's argument is coming from, but I'm unable to convince myself because of the peculiar history of the Irish constitution, because they've used the word denomination as a synonym for congregation across the board.
I follow your.
Grateful, so deep.
on Irish constitution.
So that's one, my lords.
Mr. Saeed Upar,
My lords, kindly give me just 10 more minutes. I'll try to wrap it up in 10 minutes.
already 15 minutes.
No, I understand. My lords, I have not repeated anything so far, that much is clear.
But you need to not.
I'll rush.
So much.
I'll just rush into that. So I'm only making the submission that the easier way would be threefold in terms of the lucidity of the proposition. Kindly don't elevate denomination to an exalted standard. Separate the set of rights between 25 and 26. Thereby, state has rights with respect to 25 rights as well as 26 rights. The only difference is 26 rights will be governed by 26 and 25 rights will be governed by 25 too. That is the limited submission I'm trying to make. And this in no way will do injustice either to the language. In fact, in my humble submission, to be completely consistent with the history of the provision. Because I haven't seen anyone present an argument to say, when the constitution framers, mothers and fathers and everybody else decided to use the word religious denomination, they meant this exalted standard. There is no such document to this effect, which is why I annexed all those annexures. Now, I'll just walk my lords through my written submission quickly, the rest of it, so that I yield space for others who've been kind enough, including Shri Subramani, who's been patiently waiting for me. So I'll finish quickly, minutes. Could my lords kindly come to my written note for a moment? In the written note, I'd request my lords to kindly come to para number 33. This spiral bound document at page number 22, para 33.
Yes.
I am conceding two things. State intervention is possible. And I'm also saying that state intervention is certainly amenable to judicial review. I'm making that statement. Can I read this out for the court's benefit? Just so that my position comes out here. Please, ma'am. It is, may I minutes? It is further submitted that neither in the exercise of 25(2) nor 26, the state can take over the institution of any religious institution citing maladministration. I'll explain where I'm coming from. 25(2)(a) speaks of regulate and restrict, not supersede. You can't take over the entire institution. I'm making the submission consciously in the context of HRC legislations, because in several states, the state is a squatter. It's a permanent tenant against whom there are no eviction proceedings possible, unfortunately. In this regard, I request the bench to kindly take a look at 31A of the Constitution just for a moment. Please take a look at 31A. Kindly see Article 31A, and this argument is captured at the bottom of para 33, but may I just read this for the court's benefit?
So there's no taking over as such under the state acts.
My lady, executive officers are...
Notified temple, it becomes a notified temple. Once it is a notified temple, the act will apply.
There is a slight difference. Kindly consider this. In Tamil Nadu HRC legislation, for that instance, I'm just giving an example. Specific provisions exist for constitution of trust for temples, without ever giving effect to the process of election for trusts. The state directly applies and appoints executive officer even when there are no instances of maladministration. This Honorable Supreme Court in 1965 Pandara Sanidhi as well as the Subramania Swamy judgment has clearly said, you can take over provided there is something that smells fishy, and that reason has to be recorded in writing before the state can enter into the picture. In the absence of doing so, the state starts exercising its marching powers, its police powers, and just enters the institution. So that is what para 33 covers. Can I request my lords to kindly come to page number 27, para 36 on jurisdiction of constitutional court and civil courts. I assure my lords, this will be my final submission. I will not extend any further. Paras 36 and 37, allow me to read this out for the court's benefit because I think the language has been captured better here. My Lord Justice Varale has it. Para 36, page number 27.
Yes.
Since the powers under Articles 25(2) and 26 are vested in the state, and the state does not include judiciary in its judicial capacity, Constitutional courts cannot entertain writ petitions which challenge the religious practices and beliefs of any religious institutions, whether codified or not. This is because codification of a pre-existing religious practice is merely an acknowledgement of a right under Articles 25 and 26 and is not a de novo legislation. If this position is not accepted, then the easiest way to circumvent the bar of judicial review on religious practices is by codifying such practices and thereby making them amenable to judicial review. In short, what cannot be done directly cannot be done indirectly. This also means that there is no basis for application of ERP test, since courts do not have the powers under Article 25 and 26 to preside over constitutionality of practices. In any case, as demonstrated, and kindly make a note of this, by Shirur Mutt, the discussion in the context of Article 25(2)(a) was not in respect of essential religious practice, but was in the context of essentially religious practice. There is a distinction between an essential religious practice and essentially religious practice. And essentially religious practice strikes a distinction between secular and religious. Essential religious practice is distilling what is religion. Therefore, that entire test has been misunderstood. Please see further the reason why constitutional courts have not been listed. I'll leave this minutes. Then my lords may come to.
That is in the juxtaposition of a secular activity.
I'm so grateful because the HRC legislation was the subject of discussion there of 1951. So the question was, what is secular activity associated with religious practice, as the learned SG had correctly.
Shirur Mutt was in debt. Question was, you require so much of money
Please,
for that paryaya and all that.
please.
When you are in debt.
Same Shirur Mutt that I represent was before
Yes,
this
sir.
honorable court. Please.
You see, it was in debt. And when you have 1 lakh of rupees was the debt in those days was very,
Please.
high.
Princely sum in that sense.
Yes.
Please.
So when 1 lakh of rupee you are in debt and you want to spend so much for paryaya,
Please.
whether the extent of expenditure was a question, and there was an inquiry and all that, and ultimately
Please.
they report, they said make a scheme.
Right.
That scheme was challenged by
Challenged.
the Mathadipati there.
Saying it's exorbitant and they can't
Yes.
meet it. Please.
Can't have a scheme because I'm spending so much.
Please, please. Can I request my lady to kindly come to page number 36, para 38. And this is on the question of civil courts. And these are questions that address the issues that specifically address the questions of Justice Bakshi and Justice Arvind Kumar.
25, 26.
Yes, I'll just answer this one question.
Apart from
Constitutional-
something of interest there also,
Please,
there was one practicing advocate.
please.
He wanted to take control of the mutt because the Mathadipati was a minor and then he was very young.
Please, please, please.
And he, through his friend, got a power of attorney and all that.
Right.
He started misusing that power of attorney.
Please.
There was a suit. Power of attorney was terminated by the Mathadipati. There was a suit. And when that suit was there, all this happened because the advocate there managed all that.
Right.
Sorry to say that.
Right.
And then matter landed up here and now we are in 7th judge, 9th judge.
Please,
That is the genesis of the dispute there.
please. Kindly
No
come,
essential religious practice.
kindly come to para 38 at the bottom of page number 36. Constitutional courts, however, can look into challenges to state action under Articles 25 and 26 when infraction of rights under 25 and 26 by state is claimed by the agreed parties. Please underscore the words who are bona fide beneficiaries of such rights. Even in such instances,
Limited jurisdiction. You
Please.
understand? Can come to 37, 39. Civil court, you are rightly saying that. Civil court.
on 37.
I think everyone has argued that civil
So
court.
to answer the question, that if a person within the denomination has a problem with the practice, he can go to civil court. Or the alternative in Hindu tradition is you go set up your own sampradaya. Almost every person, it's not as,
Question of, we understand, your
Please.
question of religious practice comes, then civil court
I'm so great.
will, can determine. When
Yes.
the question of constitutionality of a state action comes, then a writ court can examine.
I'm so grateful. I
25.
couldn't have put it in better words. Milords, I have nothing more to submit. As far as page number 37 is concerned, I have given the Marthoma judgment as the example where the court has held that Articles 25 and 26 are rights of civil nature that can be exercised through the medium of Section 9. And this was again reiterated in the Ram Janmabhoomi case as well, because that started through a suit only. And this was the basis of it. Milords, can I just take just 10 seconds to see if I've missed out something? I'm so grateful. Just continue.
You see the background of that dispute.
They are bound to do like that.
one submission on the question of constitutional morality. A lot has been said. Grote, Ambedkar have been cited. I won't get into that. In my humble submission, the journey from 2018, September 28th till date is the journey of misplaced application of constitutional morality, which is, as opposed to applying the is position in terms of what the law says, when we go down the path of applying the ought position in terms of what the law must say, then we're entering the realm of policy. I'm grateful, deeply obliged, and I'm grateful to Mr. Subramanian.
Yes, Mr. Gopal.
My Lord, there are three submissions where I want to express my admiration and agreement with the learned Solicitor General. Three submissions. The first is, under our Constitution, there is a separation, my Lord, between the state and religion. That is the correct submission. I support it fully. The second is, the extent of state control by way of regulation must be minimal and must be narrowly tailored to meet certain objectives. I support that position. The third, my Lord, is the position relating to Articles 26 and 25 of the Constitution. My Lord, necessarily they apply to all religions. And therefore, the question which arises before your lordships is the true meaning of the expression religious denomination in Article 26, that whether it is religion specific or it applies to all religions. Well, Lord, there is a reason why I'm saying this. Well, Lord, Article 44 of the Irish Constitution was the bedrock, shall we say, of the drafting committee. They looked at Article 44. Now, my Lord, when one looks at Article 44 of that Constitution, which I'll presently show, my Lord, it uses the word religious denomination in the context of the Catholic Church, the Anglican Church, Jewish congregations, and other religious denominations. So when it uses the expression other religious denominations, it meant each one of them qualified to be a religious denomination. So, my Lord, one possible interpretation which your lordships may have to consider is, considering all the Constituent Assembly debates, was there a need and a way to put religious denominations separately instead of in 25(1)? In other words, 25(1), my Lord, is the general principle for all persons. They are entitled to freedom of conscience, religion, and, my Lord, they can freely practice, propagate religion. But, my Lord, when you see the words in 26, every denomination, unless we want to give a restricted meaning to the word denomination, it must mean, my Lord, every religious denomination of whatever kind. So, my Lord, this is an important point for your lordships to consider. This, my Lord, will actually give equality to all religions in the first place. My Lord, the way in which Shirur Mat has been interpreted over the years requires some course correction.
Sorry, Mr. Gopal,
Yes.
for interruption. Your written submissions are in.
Yes, my Lord, I have an
one-
additional set also, which I'll hand
1.2,
over.
Page 596.
Yes, yes. And I have an additional submission, my Lord, which I'll hand over.
All right.
It's been handed. But, my Lord, I wanted to first lay out the broad sketch of what the subject is about. So the first, my Lord, is what is the meaning of this expression denomination? If the word means, my Lord, adherence of a religion, they still can constitute a denomination. If you follow a religion and you come together and you organize yourselves, my Lord, you could well satisfy the three test criteria in Justice Bijan Mukherjee's judgment, and you would be a denomination. But the way Shirur Mat has been interpreted is as if you have to belong to a known school or a known subsect within the larger canvas of the Hindu faith, which is either supported by, well, this expression, sampradaya, is again not very accurate. And I'll tell you, Lordships, why. All temples in India, my lord, are quite different. They vary totally. Temples in North India are completely different from temples in East India, or for that matter of fact, my lord, from South India. So I'm submitting for your lordship's consideration that we will need a slightly more broad-based understanding of the word denomination. And if it is broadly construed, my lord, it does not offend anybody. It only guarantees equality to all religions. In other words, well, a religious denomination, that people who belong to one faith and who come together for the purpose of practicing religion in the form of an endowment, in the form of a trust, through, my lord, erecting an edifice of learning and prayer, my lord, they would qualify for denomination. That is why, my lord, in Shirurmat, before one looks at Shirurmat, my lord, one must be familiar slightly with the law relating to Hindu religious and charitable endowments. Without that, my lord, Shirurmat will look quite difficult for the purpose of comprehension. My lord, Justice Bijan Mukherjee, before he delivered this judgment, my lord, in 1954, was the Tagore Law Professor on Hindu religious and charitable endowments. I, my lord, strongly commend those lectures because they give you a very descriptive idea of the development of Hindu faith and how this concept of Hindu religious and charitable endowment came into being. As rightly pointed out by my learned and distinguished friend, Dr. Dhawan, Ishtha and Purta, that is piety and benevolence, are the hallmarks of the faith. And therefore, your lordships will find religious and charitable are put together because of the nature of a religious endowment. Your lordships have not yet seen that there is an expression in entry 28 of list 3, which refers to religious and charitable endowments in the concurrent list. Now, my lord, therefore, your lordships will find when we deal with these cases, there will be 4 words which your lordships will come across. One is idol or a deity. The second is, my lord, the expression debata, because the property associated with an idol is called, my lord, debata property. It can be managed by a Mathadipati, or it can be managed by what is called, my lord, a Shebai. The third, my lord, is a Shebai. And the fourth, my lord, is an Archaka. And in relation to all of them, my lord, rules of succession are different. A Mathadipati, my lord, a Mathadipati will nominate a successor. But in relation to Shebayats and in relation to Archakas, and also, my lord, the concept of a hereditary trustee. So in respect of these 3, the idea was, should we have hereditary trustees, hereditary Shebayats, and hereditary Archakas? In this context, my lord, Justice Mukherjee, when he delivers these lectures, says that there are 2 kinds of temples. One is a private temple, and the other is a public temple. And the expression which my Lord Justice Sundaresh referred to in Article 25 to B is about Hindu religious institution of a public character. The reason why, my lord, the word institution was used is because you could have both mutts and you could have temples. And therefore, my lord, the expression was Hindu religious institution. And what is meant, my lord, by this expression, that is Hindu religious institution of a public character, this, my lord, is a very important question. And this includes, my lord, temples, and I submit it includes even denominational temples. denominational temples, my lord, are also for a section of the public, even if they are dedicated for a section of the public. But even then, they are a Hindu religious institution of a public character. Well, this is the decision in Venkat Ramana Deva. That decision is really based upon an interpretation of Article 25(2)(b). And once, my lord, a denominational temple is a Hindu religious institution of a public character, by the Temple Entry Authorization Amendment Act of 1949, well, the temples were laid open to all sections of public. So, Malad, the context in Shirur Math and in Devaru are different. What was in question in Shirur Math was the Hindu Religious Charitable Endowments Act itself, the 1951 Act. What is in issue in Devaru is in the context of a challenge to the Temple Entry Authorization Amendment Act of 1949. Well, please bear in mind that the act which existed prior to 49 used the word excluded classes. Hitherto excluded classes. And those, my lord, the legislature wanted to do away with that calling out people as excluded classes, because even calling out people as excluded classes by custom is itself pejorative. And that is why, my lord, that law is one of great significance. Now, my lord, let me take your lordships first, my lord, to the Irish Constitution. Your lordships will find.
Ramaniam, if I'm not wrong, Devaru actually commenced before the amendment. The suit in
Yes,
Devaru
yes,
commenced
yes.
before the amendment
Your lordship is
as a declaration, and then the amendment came in and the amendment came to be challenged.
Your lordship is right. Your lordship is right. In fact, my lord, the judgment of Justice Govinda Menon in the High Court is very instructive in that case. Although, my lord, on one aspect, your lordships may have to take a different view, but otherwise, my lord, it's quite helpful. May I first place, my lord, the Irish Constitution? Where is it? A group of them, then, my lord, we don't have any difficulty. But because in Shirur Math, Justice Mukherjee, my lord, with his profound knowledge of Hindu religion, was able to easily identify the Madhva Sampradaya and was able to, my lord, discuss theologically what were the broad features of that faith, my lord, therefore was able to expound in that case. But that is not, my lord, entirely the way to look at denomination for the purpose of giving effect to 25(1). When you come together, you really exercise, again, the right to freedom of religion. But that is, my lord, dealt with in 26. My lord, I take the position that Article 26 is necessarily subject to Article 25(2)(a) and (b). My lord, without it, I submit, my lord, that's the only way to read Articles 25 and 26. But, my lord, let us look at the very foundation.
Just
Namely,
repeat it again, Mr. Gopal. Your stand on 26 and 25?
I'm saying, my lord, Article 26 is not a standalone article which can survive without reference to Article 25(2)(a) and (b). So, my lord, a denominational temple can be subjected to a social reform law.
Yes.
A denominational temple can certainly be subjected to a law by which, my lord, the gates are open for all classes of Hindus. My lord, that is very vital.
Please explain as to how all denominational temples would come under purview of Article 26 to B.
26,
2B.
25 2B?
25 2B, yeah.
Because if your lordships agree with me, that public institutions for worship can even mean denominational temples, and that is one of the decision.
Could there be a denomination temple
Yes.
which may not be a public institution?
My lord,
It may be a Hindu religious institution.
yes.
But it may not be a public institution. Is it not?
My lord, unless it is a private temple,
Yes.
say, my lord, a temple dedicated to the members of a family,
Family.
then of course it is different.
But that, it can be a denomination also, religious denomination also.
My lord, there is no concept with respect. I'm
Yeah,
grateful you
unless-
asked that question.
Unless you define and then tell us what do you mean by public character? Can you say that every denomination, religious denomination would come under the purview of 25 2B?
My lord, if
We
you
want to know, because if we go by what you're saying, then we have to say that then every other, merely because it becomes a denomination temple, religious denomination, see, automatically it comes under the purview of 25 2B.
my lord, that is, in other words, my submission is every denominational temple, not a private temple, but a denominational temple, is an institution of public worship, and therefore Article 25 2B will apply, while it will retain its freedom to manage and administer affairs of religion and the property under Article
We are only asking
26.
you, see, supposing 3-4 families to join
Yes.
together, a small community. Can't they have a denominational temple or religious denomination of their own? If they have it, how do you bring it under 25 2B?
My lord, with respect, once you have even, let us say, a group of people, the point is, if you allow the public to see the temple and it is for public use, then, my lord, it is impressed with the character of a public worship. As long as, my lord, and that is why I submit with the utmost respect, this concept of denominations only for private, well, the concept of denominations being only for private character is actually, my lord, misconceived.
That's why Venkatramana is correctly decided.
It is correctly decided, my lord. It should not be overruled. And they all can be harmonized. Venkatramana Devaru and Shiru Mat, both are correct, my lord. And look at the, one of the extraordinary thing. These lectures, the Tagore Law lectures, the second edition was none other than Justice Venkatramaya. The third edition, my lord, was by Justice P.B. Mukherjee, the Chief Justice of Calcutta. And the fourth edition was by Justice Gajendra Gadkar.
Well, there's a fifth edition. You make
Yes,
kind of
that is AC Sen.
Yes, it is. And he has authored some of the judgments.
Now, my lord, if your lordship just takes this compilation in hand,
Both can be harmonized.
yes, both can be harmonized. Yes.
Otherwise, you see, if you keep 25 2B, if you say it cannot come anywhere near 26B, in the sense that it doesn't, you see, otherwise it will affect the denominational temples also.
It will, my lord, and I'll tell you.
And then you are saying it, that also in a way divides the people as such. If you say right of entry is not there, etc.
In fact, my lord, the reason why 25 2B is couched in that way is actually to give effect to the right of religious freedom and worship of individuals who belong to the excluded classes.
Yes.
That is the purpose of 25 2B. So 25 2B is actually in furtherance of 25(1) in spirit. That is, those who could not exercise religious freedom of access to a temple were now granted access by a law under 25(2)(b).
Then 26B is not affected at all.
Then 26B is not affected at all. That is why in Venkatramana Devaru, Justice Venkatramaya very meticulously said that whatever is relevant for denominational practice is preserved. And that, my lord, is the same position even in Seychelles, except there is only one error in the judgment. After finding, my lord, that the appointment of an archaka is a matter of usage, the learned judges erred in calling it a secular usage. That is the error. Otherwise, my lord, the rest of the judgment is capable of being supported. The judgment, my lord, in Adi Shaiva is a complete answer because it, my lord, establishes that anybody who undergoes the worship at a temple must follow the agamas and the shastras, which is, my lord, which runs with the temple. My lord, incidentally, agamas are not Vedic. They are actually Puranic. And, my lord, we have states where you have both, my lord, agamas in Brahmi, in Sanskrit, and you also have in Tamil. So, in the tradition of Saiva Siddhanta, in Tamil Nadu, the agamas which are followed are essentially Tamil agamas. And that, my lord, is also important to keep in mind, because many of these descriptions which your lordships find in these judgments is in the context of some agamas in some temples. They don't necessarily portray to you the wide width of agamas which, my lord, can be prevalent in a temple. My lord, another thing is, it is not necessary that for a temple you must have an agama. You can do worship even without reference to agamas.
There are non-agamic temples also.
There are non-agamic temples also. And, my lord, in many temples in north of India, my lord, they are not necessarily related to an agama, but they belong to the Hindu faith. So this, my lord, is the wide conspectus in which your lordships are being called upon to consider this question. My lord, may I begin with showing you Article 44? Because that will...
Mr. Subramaniam,
Yes, certainly, my lord.
Can we go retrace our steps back to the beginning?
Yes.
Kindly read Article 26 with me.
26, my lord.
Yes. Freedom to, have you got that?
Thank you. Please, my lord.
Freedom to manage religious affairs, subject to public order, morality and health, comma, every religious denomination or any section thereof. Let's pause here. If any section thereof meant that it is part of a denomination, then it could have said every religious and any section would also be part of a section of a denomination. Why this word religious denomination? I'm giving you an answer also. What is coming to my mind, I'm just throwing up in
Certainly.
I'm just thinking aloud. We have to go back in time, 70, 80 years back when the thing was being debated. At that time, India was multi-religious. It is dharmic sampradaya. At that time, every religion was also referred as Muslim sampradaya, Hindu sampradaya. The religion was the sampradaya. The religion was the denomination. In that word, if we can approach this, I think that many things will fall in line. Then the word any section will not become superfluous. Once it is denomination, sampradaya means it's a way of addressing a religion at that point of time. Today also people refer Muslim sampradaya, he belongs to this sampradaya, he belongs to Isai sampradaya. The whole religion is taken to be a denomination and a sampradaya. I'm using the word at that point of time. Now things have changed. Now it is being more particular, very Shaivite, Vaishnavite, Shia, Sunni, everything has come. But at that point of time, then any section will not become superfluous, because any section, as it is, will include a denomination. If we are trying so much, harping so much on giving a separate definition to denomination, can we get over that denomination fixture, which is now being fixating us?
Lord, your lordships are right. In fact, there is a sentence in Shirul Mat, which is often overlooked, which is, my lord, the ground on which fundamental rights were upheld, both under 25 and 26. My lord, the Mathadipati's right was actually found in 25 in Shirur Math, because if you want to propagate religion, it must be through individuals. And therefore, the Mathadipati had a right under 25.1. As far as 26b is concerned, my lord, there are crucial words in the judgment of the learned judge, which uses the word section thereof. My lord, those words are very important when I place it. Your lordships will find Justice Mukherjee is conscious of the fact that generally you have Hindu faith. Hinduism has many philosophies and schools within it, and one of them is the school of Madhvacharya. And you have a section that is a denominational community which actually manages that temple. And therefore, he said, it is a section thereof. Really speaking, my lord, if you read Shirur Math closely, it was in the context of a section of a denomination. That accords with the interpretation which I'm suggesting, because when your lordships look at the Irish constitution, it will be clear that the word denomination was in the context of all religious. And that is why, my lord, in 26, we have the word every religious denomination. What is the meaning to be given to the word every, when you find that it is preceded by Article 25, which only says religion? So, my lord, religion of different kinds, bearing different, my lord, I will use the word faith very carefully, because faith is, my lord, actually a derivative, a private experience, which can happen as a consequence of your adopting a religious practice. But faith, my lord, is an area of some subjectivity. We should use the word religion here. Religion in 25 and denomination in 26 means every religious denomination. If that is done, my lord, you are applying it to all religions. You are not, and you are applying the threefold test. My lord, there's nothing wrong with the threefold test expounded by Justice Mukherjee in Shirur Math. It is as good as any other test. You will not find any great improvement, my lord, upon that test. It is only to show that you come together. My Lord Justice Sundaresh asked a question that how does a denomination acquire a persona, a personality? Lord, the denomination can be through a trust. A denomination can be through a foundation. A denomination can be through a society. A denomination can be through an endowment. Well, this concept of endowment was that there would be a dedication. The dedication had to be followed with some specific objects. And one of the objects, my lord, would be to offer to a section of the public access and worship in the temple. This is how, my lord, this law has developed. And if your lordship now sees the Irish constitution with me, this would be completely evident, my lord. Please see Article 54. It's additional volume 6, page 5. Please see page 5. Your lordships will find Article 44. My lord, it occurs in 44.3. The state also recognizes, my lord, Article 44.2 recognizes the Catholic, Apostolic, and Roman Church. Then third, the state also recognizes the Church of Ireland, the Presbyterian Church in Ireland, the Methodist Church in Ireland, the Religious Society of Friends in Ireland, as well as the Jewish congregations. Well, the Jewish congregations are a different religion. They follow Judaism. And the other religious denominations existing in Ireland. So the other religious denomination clearly says it means every denomination linked to a religion. And, my lord, this is fortified by the CAD debates. My lord, in my additional submission, your lordships will find I have actually given a complete progression of the discussions in the draft articles. Your lordships will find at all points of time, it is every denomination. The reason is, my lord, in Article 25.1, there is the use of the expression religion. But that, my lord, means the existence of a doctrine or a faith, which can be, my lord, of various kinds. It can be, my lord, without a deist, without a creator, like Buddhism, like Jainism. And, my lord, the reason why they have been clubbed with Hinduism, my lord, is due to ancient philosophy. Because, my lord, both Jainism, Buddhism, they all grew alongside Hinduism before the 8th century AD, before Shankara appeared. One thing is clear, my lord, that this expression, every denomination, throughout the drafting process, it is very clear, was in the context of religion. So your lordships will find, if you read 25.1, my lord, 25.1 declares the right. 25.2 is adherents can come together and exercise religious freedom under 25.2. So, my lord, religious freedom is also very vast. In other words, in the private space, it can become a part of your dignity. It is a part of your inner self. It is a part of something which inheres in you by virtue of being a human being. My lord, the right to conscience is also, my lord, an inherent, innate human right. It has been so declared. In fact, my lord, the 1948 Declaration contemplated this belief that all people, the whole of humanity, must be treated alike because they have the same inherent rights. One of the inherent rights, my lord, is conscience, freedom of conscience. Now, freedom of conscience, my lord, need not necessarily be linked to religion. My lord, I must make it clear. Conscience can be purely as a result of moral discernment using your own reason, and you can come to a conclusion that is within the realm of your conscience. But your conscience can also be influenced by the practice of faith and by experiences, my lord, what William James described as the adventures in religious life. So it, my lord, is a matter of being influenced and persuaded by the tenets and practice of a faith. My lord, I must make one clarification. The Solicitor General referred to Dashanam. My lord, that is actually Dashanami. My lord, I just wanted to clarify it to you. That is the order of sannyasis established by Shankara. And my lord, you can select one of those 10 orders. But my lord, there are many orders of sannyasa where this is not a condition. You don't have to belong to a particular caste. For instance, my lord, the monks in the Ramakrishna order, they are, my lord, an example. In fact, my lord, it is something very, very progressive, which was attempted way back, my lord, when the Math was established. Now, my lord, if your lordship now sees, therefore, Article 44.3 in the light of the Constituent Assembly debates, and I'll show you, my lord, in the Constituent Assembly debates, there is no suggestion of what is called a non-denominational public institution. There is no suggestion of a non-denominational institution for worship, public institution. So, my lord, this idea, my lord, so the idea which has existed with many judges is that denomination is a subsect. If you want to be non-denominational, you must find yourself in 25.1, in the ocean of 25.1. But if you are denominational, you have to prove something specific, something unique, something which is so extraordinary, which distinguishes you from the normal faith of Hinduism. But that, my lord, is not correct. That is why I submit with the utmost respect, the Orwell judgment is correct in terms of its understanding of Sri Aurobindo's philosophy. My lord, about how he wrote his books, whether it was the essays on Gita or the Ascent of Man, that was a philosophy. So it necessarily would not qualify for treatment as a religious right, even under 25.1 or 26.2. But the definition of denomination adopted in the Orwell case, my lord, is not correct. So in my humble submission, denomination, and this way, my lord, you will be giving complete equality to all religions. And my lord, that expression is very important. My Lord Justice Amanullah referred to Sampradaya. My lord, the word samata, my lord, equality, has three facets in our constitution. it has one, my lord, in the secular sense in Article 14. It also has, my lord, equality of all religions, which is actually 25. That is called Dharma Samata. So, my lord, you have equality of religions, and you also show equality to each other, which is called, my lord, Sattva Samata in my lord. Therefore, this principle of equality, equal respect for all religions, is also a part of 25.1. And that can be furthered, my lord, only if you read 26.1 liberally to mean adherents of any faith, who come together and who have a sense of organization, and who, my lord, when they say a distinctive name, something to identify them as a special group who are pursuing, my lord, the tenets of faith.
The triple tests, the three tests have to be passed by them?
Yes, they have to be passed. So as my Lord Justice Sundaresh said, as long as you are members of a faith, you come together and you resolve to constitute yourselves into an organization. And that organization follows the tenets of a religious faith. Well, not following the tenets of a religious faith is integral to the existence and qualification as a denomination. That is why, well, this mystery is resolved when your lordships read the Trinity of Judgments. Well, there were three judgments, as rightly pointed out by Dr. Dhawan. One is Shiruma, the second is Jagannath, and the third, my lord, is that Ratilal. In Ratilal, your lordships will notice he uses straight away Parsis, Jains as denominations. Your lordships will notice in Justice Mukherjee's judgment, he straight away ascribes them as denominations. So he clearly understood that the word faith, religion, well, there are so many religions, and in India we have many faiths, and therefore he said that all of them are different denominations. The fact, well, that the Constitution, for the purpose of enablement under 25(2)(a) and B, says that some institutions which are Jain, Sikh again, my lord, because there is an overlap with Hindu faith. So they have aligned with either those religions which came up, my lord, around the same time as Hindu doctrine flowered, along with other religions. That is why, my lord, they were put together. This is why, my lord, you have that explanation in the article, bringing Jains, Sikhs, and others in the same breath, that they would be deemed to be Hindu religious institutions. So, my lord, this expression, institution, why the word institution was used was because we had a monastic tradition in one faith, the Hindu faith. We, of course, have, my lord, monastic traditions in other faiths too. But in the Hindu faith, the monastic tradition led to endowments, what are called mutts. And these mutts, my lord, have endowments. My lord, one important factor which your lordships may keep in mind, which is the golden thread of Justice Mukherjee's lectures, is he says, this is so important because the objects of the donor must be lawfully subserved. That is, all the usufruct which comes from an endowment must be capable of being plowed back for the purposes and the well-being of either the mutt, that is, my lord, propagation of knowledge, or for the maintenance and the care of the deity. And the deity there, my lord, and again, with respect, my lord, it is not only this school of worship of deities which is protected under 26. There are many forms in Hinduism itself, some who believe in direct, my lord, that is, there is a direct process of initiation and you contemplate on the higher truths and higher realms to achieve a certain state of transcendence. Even that, my lord, is a denomination. So as long as you are able to show the tenets of your faith, my lord, if you now look at that expression tenets, this expression, this great debate we've had about essential religious practice will also melt. What is meant by tenet is something which is doctrinally fundamental to the faith. And that, my lord, is necessary because when somebody actually propounds a case that his religious freedoms have been violated or infringed, he surely must be able to set out his case. What is the faith which he is following? And what are its basic tenets? Well, that is extremely important. That is why my Lord Justice Bagale asked a question today, that today at this distant passage of time, my Lord, we are not exactly in 1954, we're in 2026. We have access to knowledge. We have greater rational faculties. All these, my Lord, are relevant for the purpose of a secular view in relation to the articles of the Constitution. But, my Lord, the interpretation must take place in accordance with constitutionally established parameters. My Lord, one important thing is the religious freedom is only a facet of the individual freedoms under the Constitution. The freedoms which are granted by many other articles, my Lord, there are two kinds of freedoms. What is called, my Lord, positive liberty, and the other one is called negative liberty by philosophers. Some of those freedoms are to be found in 19. And of course, now, my Lord, because of the development of our constitutional law, where we have merged 14, 19, and 21 for the purpose of understanding the nature of fundamental rights, that is one important factor. My Lord, the relevance of many of these anti-exploitation provisions and protection of children, and also removing, my Lord, the complete evil of untouchability, which is, my Lord, consciously put in quotation marks in the Constitution. And it is put so because the Constitution framers, my Lord, were not only aware of history, they were conscious of history, and they wanted, my Lord, social reforms to be always available. My Lord, over a period of time, social reform has taken place. Right from the time of Raja Ram Mohan Roy, my Lord, social reform has taken place. And Dr. Ambedkar, my Lord, if he is correctly understood, was a great proponent of social reform. And he believed in this doctrine of equality. And yet, my Lord, he wanted to protect religious freedom. He was, my Lord, instrumental not only in promoting equality, in not only being conscious, my Lord, of Article 17 and the ills which have befallen society. My Lord, people are not aware. He was an anthropologist before he became a lawyer. And he was a social anthropologist. He has undertaken such extensive research on the subject of untouchability. In Justice Chandrachud's judgment, my Lord, in the Sabarimala case, although there is a chapter on untouchability and Article 17, the most important work of Dr. Ambedkar, which is called The Untouchables, my Lord, there's a book which he wrote. And that book, my Lord, is actually the most seminal work for the purpose of understanding why Article 17 found such an important place in the Constitution. So, my Lord, our Constitution is a promise for the future. It is an assurance against discrimination. And most importantly, my Lord, discrimination in relation to access to public spaces is protected in 15.2 and 16.2. But, my Lord, discrimination in relation to access to places of religious worship must also be protected. That is why, my Lord, you have Article 25.2b. So, my Lord, if a denominational temple, and this, my Lord, I must tell you, Lordships, many judgments have made this error. They thought that if it's denominational temple, it is almost like a private temple. But that, my Lord, is an error. May I, my Lord, pause at this moment?
We continue to.
Certain.
What is the year of the Irish Constitution? It was enforced in?
My Lord, this is the 1937 Constitution. And, my Lord, interestingly, in 1973, my Lord, except for one article, the other subsections of Article 44 were deleted.
Where other denominations, maybe they meant Protestants.
No. Other denominations, not in the context of Jewish.
No, Protestants also.
Yes, I agree with you.
They didn't want to name the Protestants.
They didn't want to name them. But, my Lord, the word in the context of Jewish denominations being there, other religious meant, my Lord, each religious.
Article 44 doesn't mention Protestants. So they just put them in that bracket.